if these programs center, these initiatives center around the idea that, wow, a lot of this data is already collected. We have DEM files for 14,000 EMS agencies across the country in the national data set. If we could kind of bring to fruition the initial vision of the DEM file, right, where it's updated on a regular basis, the information that states want is updated and kept up to date, then yeah, this could meet a lot of that need. So the idea here is to talk a little bit with the vendors and with the states about kind of, is that a possibility to kind of move this into a more routine updating type of a process where it becomes valuable data and we somehow cue our agencies to keep it up to date. I know when we first rolled out the DEM file, right, there were even agencies or there were states that were even filling up DEM files for agencies. So agencies didn't need to do that. Want to kind of get a feel for if those kind of things are still happening. So we'll just walk through these questions. We're taking good notes and we'll see if we can come up with a process that allows for the DEM file to meet its purpose, right? To actually be utilized. And I think the UUID will greatly help with the ability to kind of keep these updated. So hopefully that will help with a lot of the issues that have existed in the past. So let's go ahead and dig in. You can see the questions here. What are the impediments that exist that hinder agencies from updating their DEM files on a regular basis? I'd like to hear the vendor side, and I would love to hear the state data manager side. Any thoughts?
Hi, good morning. This goes way back to version 2, well, beginning of version 3. There was no requirement for a DEM file to be sent in the original talking. So that meant that, from what I recall, they weren't automated like an EMS record. So if you would make them required on a basis, whatever that may be, then the vendors would be motivated to make them be automatic. And that would help a lot, because manually sending DEM files is time consuming. That would help a lot. The other thing was, this may not be part of what you're asking, but it is based upon what you just said, wanting to know how many agencies there are, what levels of service and things like that. And then looking at D agency 11, it's asking for the minimum certification level offered by that agency. So if they got ALS and BLS, they're going to say everything is BLS because it's the minimum level, versus what's their highest level they offer, which would answer Eric's question. They would be ALS. So though, I think automation is the biggest thing.
Okay, that's great. Yeah, and the actual variables that are in there and what comes up to the national level, I think that discussion will also be opened back up. Is there another runner for the microphone NEMSIS team? Can we get 2 folks? I think there was a couple of other hands up. Who else had comments? Chris has a comment, and then I'm sorry, Drew. That's right. Thank you.
Yeah, for online. Kevin Putman says that our vendor is unable to import a demographic file for an agency without screwing up the state's data. And Josh Nation says that we have found some of the validation requirements in some of the state DEM files for newly formed agencies can be a bit over encumbered. Existing is not an issue.
Okay, thank you for this. Yeah.
Chris, can you email back or chat back on that second question? When he says over encumbered, does he mean that the amount of work it takes to get the initial data in there is the issue, or is it something else? Is that clear to you, Clay?
No, let's see what.
So Josh says some of the information required is not available for the new agency.
Oh, okay.
Many of those have been removed in version 3.5, so that section will be easier. Sorry, Drew.
I think sometimes there's an assumption that these agencies are using an end-to-end solution with a single vendor, and oftentimes find is they don't want to document the same information too many times between two different systems that are not exactly connected, just through more basic interfaces.
So you're saying the field level product, when they complete a DEM file, it's not coming across correctly in the state level product?
I'm saying that they often have different systems for HR purposes where they document a lot of the things you want in your demographic file.
Yeah, you're right. And that's the second question. That is a great question, and we will get to that. Yeah, thank you for reminding us of that. Any thoughts from the software vendors? Yes, Samantha.
Hi, this is Samantha with ESO. One of the things that we've seen is people have the DIM file go, but they don't come back to check for the errors like they do
For
with
EPC.
Eden. Yeah, and so they think it went because they didn't go back and look at the report.
Yeah,
That's the problem for us.
yeah. Good thought, good thought. So that's a technology issue to deal with. Yeah, thank you. Can we skip to the third question since we're kind of on that? Let's stick with kind of the technology questions. Does it make sense if we want this updated? Can we develop a system where we standardize perhaps and check in compliance or something? Maybe we don't need to go that far, but is there a way for us to kind of standardize the approach to just kind of cueing the agency that, hey, it's been 6 months, maybe it's time to take a look at your file again? Keenan?
It's on now. We can do anything with enough time and money, right?
Yeah,
I think that reminding and automatic submissions are two things that we have to keep in mind, that no matter how many times we send or how many times they push the send button, without them accurately updating the file, you're not actually going to get good data.
yeah,
And back to Drew's point, if I'm doing if I'm an HR software, I have a dispatch software, I have a licensing software. This is now the fourth software where I have to update all of my demographic information.
yeah, you're right. I think if it was, once it's filled out, it perhaps wouldn't be, well, I don't know, right? I don't run an EMS agency, and maybe there are areas where maybe the larger conglomerate is completing records for many agencies, and so that may be problematic. Hey, Josh, from the questions online, I apologize, I'm not sure which of the two. I think they were talking about some of the validation rules that are associated with DEM files, that maybe they're a bit restrictive. We have national schematron rules for the DEM file, right?
Yeah, we do.
Do states add additional validation rules to their DEM files? Some do.
I think
Okay.
only 2 or 3 states have published a state schematron schema for demographic data.
Okay.
I
Okay,
know
good.
Oregon and New York, there might be 1 or 2 others.
Yeah,
That's been it.
okay. Any other vendors want to comment on any of those issues? Developing a process whereby they're reminded to just update their DEM files and ensure that they can be resynced. Kelly?
I think it's also an education thing. A lot of agencies in the field, they're not really worried about making sure that like their contact information and facilities and all that stuff get up to the state. And a lot of times they don't have the time to go look at how many numbers of runs they have per year. And they don't understand the importance of the demographic file and how that works at much less their level versus the state versus the national level. So I think there's a big gap in education and what all those fields mean and why is it important to collect it. I think there's a big missing link there at the agency level. So I think you guys put out those really nice just documents that we could kind of share, like the HIPAA thing with HIE. It would be nice to have something like that, and maybe you do.
We don't, but we could certainly do that, talking
It would,
about
I
the
think it would be
purpose, the
helpful because we could
importance.
just pass it right off.
Yeah, that's a great idea.
You touched on the question I wanted to ask, which is who uses it? Right, but I guess what I'm asking is, does the state use the dump? Does the state, besides the Fed who's interested in it right now, right? It has different use cases that they talked about in different agents. Who uses it? Does the state use, so your state uses it? So the
That's a
states
great
actually use this. We're not asking for something to be developed and built that's not being used by anybody else. That's one key question, at least for me. Because I hear multiple systems for licensure, multiple systems for tracking various other things. Where does all that come together at? And that comes together usually at the state. But is the state going in and looking at that, or when they have a specific workforce question, they look at the licensure database? If they want agencies, they look at another database. Is that kind of the way it works in different places? I mean, I'm familiar with Maryland, outside of Maryland, not very familiar with. Yes, ma'am. Or I'm sorry, you mic up here. I'm sorry. I'm sorry, Adam.
We'll get back to you, Adam.
Yeah, so in Montana, we have both the LMS and the Elite system, and we license our agencies through LMS that syncs to Elite and that pushes the DEM file. But we use the DEM file quite often. Anytime we have legislative requests for information, we use the DEM file. Anytime we have requests for information, I'm probably in there 2-3 times a month pulling information on EMS agencies, whether it's a local request or a state level or federal level request.
And that's good to know. I mean, we're approaching this from what would we like it to do, or what would we like to know, or what we'd like to be able to report out for what purposes. But there's a step that's already in place, which is how is it being used today and what's the use cases for it now? Adam.
It was someone not adding comments until Wendy Miller, who does a lot of the processing for demographic files for onboarding customers, is back, but I can't put her on the spot and walking in the room. I think a lot of the issues that we had with DEM files, no doubt a reminder system, we don't have that kind of built out to remind people. But also, I think up until recently, there wasn't really a tremendous focus on the demographic file. That
You're right.
in the past, it was taken care of by maybe the state system or something, but I did notice maybe over the past year and a half, a lot more states have been requesting it. So certainly demographic is not new, but certainly it only seems like in the past year has been a focus year and a half. And I think for the most part, a lot of us are still looking at 3.5, in the PCR changes. So it's topical. We're looking into it. I just didn't think it got its due time yet. And then the other thing that I think some of the difficulties in it is there's a lot of repeating structures in there, a lot of crew personnel, right? So when you hit the schematron, it'll say like, missing certification, but it won't say who. So if we rewrite the schematron a little bit to actually address like the name of the crew member to actually spit that out, then we can make some improvements on helping them fill it out.
Yeah, good thoughts. Really good thoughts. Yes.
So Wisconsin set up a lot like Montana. We have the LMS system that syncs with Elite and then pushes the DEM files. I'm super new in the role as data manager, but as EMS regional coordinator, there's a big push to get the DEM files from agencies. We had a lot of missing elements, and it was pretty much the worst process ever because services just don't respond to you and they don't know how to fill it out. So I think a companion document would be really helpful for the services and also for the people collecting it. Because when I was first hired as regional coordinator, I didn't know what some of those data elements meant either. There wasn't a really good place for me to go looking for it.
Good thought. Good thought. Any other comments regarding technology or issues with the state? I'll throw out the question, are any states still completing DEM files for agencies in Arizona? Okay, and
yeah, I fill it out just because we have it part as our application process because we were never getting it and I was getting sick of stuff getting rejected. So they have to tell me all the stuff that's mandatory so that I can then submit a DEM file. But I was doing, I don't remember who mentioned it. Even I didn't realize some of my DEM files were failing to go to NEMSIS until I get failure notices from you guys. And I realized that some of my postings had failed. So I think if I didn't notice it. I can totally see an agency not noticing that too.
Yeah, yeah. So that's the check, right? To know which DEM files we don't have, right? Is if an agency tries to submit data at the national level, if we get that data from an agency at the national level, and we don't have a DEM file, then Monet and others have been good about contacting, and you've all been very good about reaching out and trying to get them done. And I know it's a task. Is there a better way to incentivize agencies? I love the idea of like a 1-pager or 2-pager that talks about the value of it. Oh, yeah, please.
I forgot to add too, so recently we've been pulling a lot of the data to for our governor's office, and our EMS agencies were awarded $11 million as a grant to apply for. And they were looking for the organizational type and status and whether they're volunteer, paid, all of that information. So we were lucky that we did this big push to collect all that information.
Oh, yeah, so that's a great incentive, right? You're using that to distribute funding to the agencies. Yeah, that's great. Yeah, I'm sorry, Brendan.
Okay, Florida oftentimes is on the bleeding edge of this. We can thank Ty for this, but we actually in our 3.5 data dictionary have included a demographic data submission policy, which is requiring them to send it more frequently, and we want it once a month.
Oh.
Or we want it when anything changes. Now, we realize there are going to be differences for agencies if they have a different HR system, but we have talked with some of the vendors and it looks like that some of the vendors can update that personnel and send us a demographic update for that. So we are going to give it a shot. And we're putting it in our data dictionary. Ty, you may want to speak more to that, but
Great, thank you. Yeah,
I'll let
that's
you know how it hurts.
great. Mark, I'm sorry. Yeah, please.
The way that Montana deals with the updating is that we've built the DEM information into the ambulance license or service license renewal application. So every 2 years, they have to complete that information to renew their license. So
Okay.
it's not updated annually, but biannually.
So we implemented a policy that we won't turn on the ability to be able to accept EMS data unless they've sent us a DEM file that's completed and passed. And I know that some vendors didn't like that, but it's been very good in order to make sure that we have at least the initial DEM file. And then the intent is when people move to 3.5, they're going to have to submit a brand new DEM file for 3.5 as well.
Okay.
I would say that what I did notice in some of these is they'll send one crew member and one vehicle and one station. We don't know if they've got 100 crew members and how many of what, but they'll send one. So you don't really know how complete it is.
Yeah.
But at least we're getting the initial, we'll get the update. And then go from there.
The only thing I wanted to add is a lot of the focus becomes on, as we've been dealing with COVID and personnel and things. Agencies go in and want to do it and update, but the thing you have to remember is they're losing people every day and they're gaining new employees every day.
Yeah.
So I can promise, and this is something we've looked at as a whole internally as our own vendor and obviously with everyone we worked at, we're working on developing a process. We're going to be sending DEM files every day. So it's literally a daily thing just to keep up with the agencies. And if they might have 5 personnel or volunteer agencies, but it's the challenge to just automate it because it's impossible to do. And if it's not tied to the people, it just has to become a daily function to send a DEM file. And as we looked at the scope of things and across our footprint, we lose, 50 people a day at 150 people a day. And so it becomes just that you have to build it into your workflow if you want to see the effect of it.
Nice. Yeah.
Yeah, to everybody's point with the how many or the quality of what's being put into it. This is why we recommended and we were trying to pursue that any interface, user interface, a new medic gets hired, they get put into the system to have access to write PCRs, that be automated into the DEM file and then an automatic submission be done. Whenever you buy a new truck or trade out a truck, that gets entered into the system so you can mark yourself on your EPCR as what unit it is, that automatically get added into the DEM file and resubmitted. So anytime that there's a change in the user interface, that automatically ties into the DEM file and gets sent in. So that's what our hope is in Florida. And you can send them to us daily, hourly, but at least monthly. We,
And that's a software vendor,
yeah, we're
feature.
hoping that our vendors would think of this as a less impact on the agencies to automate it for them and kind of build in that pathway for them. Because if we rely on the agency to do it, it just isn't going to get done.
Yeah. Samantha.
So one thing about the automated submissions is we have it automated, but if there's a validation rule, it fails. And there's no one going back and looking at that automated validation error. So that's where
Yeah.
we're seeing a problem.
Yeah, so that's interesting. So we got to work out some way that they're able to see their warnings, right, or see their errors. Yes. Oh, I see. I see what you're
If they
saying.
don't,
If
if
they
they
don't know
don't
what's
realize it's
happening,
going automatically every day, they don't think to go and look and see, did it pass or not?
okay, okay.
And so if there's that one failure that happens that one day, if they don't go back and change that one person, it just continually fails.
Right. It sounds like even if it was automated, though, that warning or error could be presented in some way. Yeah.
Yeah, and Clay, just to add upon that, it's also about prioritization, right? Because they may get notified that this has failed, but this is at the very bottom of their priority list. So it could be days or weeks or, longer for someone to even get to that.
Yep. Yeah, those human factors, of course, are incredibly hard to manage, and we're not wanting to be to carry a big stick, and we clearly don't have a big carrot. So I think we're coming in. Any last comments? Yeah. Please, Josh.
A couple of common issues I see. One is, in various software products, they'll have lots of good real-time feedback in PCR data entry, and things are flagged like as they're entering data. And then you go over to the demographic side and you don't see any of that. So it's just a maturity thing. I think the focus has been on the PCR side. So that would help with validation. Another common thing I see is systems that do more than just EMS reporting. They do fire reporting and other stuff too. And but it'll export all of their personnel, whether they're EMS or fire, right? And then all these fire personnel don't have state EMS license numbers. And that becomes a problem when you submit it to the state. You're submitting all these personnel who aren't actually EMS personnel. They're personnel for some other reason, or they may even be administrative staff. So they've got access to the system, but they come out on the personnel list. There's just that kind of, we haven't developed that maturity, I think, of refining things on the demographic side. Lots of room for improvement there.
Yeah, thank you. That's a really good comment. Eric, any last comments? All right, fantastic. Any last comments? 1 minute left. Great ideas. Thank you very much. We'll polish those up. We'll put together those ideas, and then we'll be talking about that during implementation calls during the year. All right, Ryan, may I introduce you just real briefly?
Oh, sure.
So Ryan, of course, is with Page, Wolfberg, and Worth. We have had such an incredible relationship with PWW over about the last year and a half. Questions that you have brought to us regarding body cams and other things that we have just really required a legal opinion regarding how to approach those and provide you with education that you can help with your states. They've been incredibly helpful. This has been a really hard one. So this, the work that Ryan is going to present really springboards off of our last a meeting together that was virtual, and we were talking about how can we improve the ability for e-outcomes to flow back into the EMS record. Some of the big concerns on the political side, not on the technical side, but kind of on the political side was, wow, can you really add hospital data to an EMS record and have that still be still be a bona fide signed record? And is it still a legal document? Is the EMS provider now responsible for the data that was put in by the hospital? All those questions, it was a myriad, probably 10 questions that Ryan and his team have really worked hard to solve this. And I know this has passed over a lot of the desks in your office. And
Yeah.
so there's been a lot of work done. So I'm very grateful to have you here, Ryan.
Thank you, Clay. I'm gonna fire this up here. All right. Sure. There we go. Okay, can everybody hear me if I'm in front of the podium here? I like to roam around, all right? I like to interact with people. So first of all, as Clay said, my name is Ryan Stark, and I'm a partner at the law firm of Page, Wolfberg and Worth. We represent thousands of EMS agencies across the United States. We also represent software companies, non-emergency transportation providers, counties, cities, you name it. We do a lot of work in the industry. And so a lot of stuff that we do, I'm sort of the resident HIPAA nerd in the office. So I'm thinking this is day 2 of a NEMSIS conference. One of the things that I go to every year is something called the HIPAA Summit, right? And it takes place, and it's exactly how it sounds. It's like a Star Trek convention for HIPAA nerds, right? And that's a 3-day conference. So imagine what's going on there. So I really appreciate being here. And by the way, when NEMSIS approaches us, it's never been like, hey, by the way, we need you guys to draft a paper to say this for us. It's always been, hey, we want to know what the right answer is and put it out to the masses. So that's not what it's been. And that's not what we do at our firm. Like if a client wants to do something illegal, I'm going to tell them not to do it, right? So that's exactly what we've done for NEMSIS as well. We've researched these issues. Some of these questions that we're going to talk about today are still making their way across the desk, but I want to give you guys some information. First of all, we talked about updating DEM files. Remember too, the your EMS agencies, whenever they hire somebody, they got to be running that individual through the OIG exclusion checklist. Also, anytime they add a vehicle, remind them too, they got to add that vehicle to their 855B for Medicare billing purposes. So for your billing clients out there, just want to make a reminder of that. Also, another update just came out, proposed rule. There's going to be a new animal on the scene starting January 1st, 2023. It's called a rural emergency hospital. You guys heard of this? It's like a step down from a critical access hospital. But one thing they cannot do is admit patients. They can't see patients for an average of over 24 hours. So during COVID, we had a lot of facilities shut down, because of low staffing. They wanted to permit critical access hospitals and other agencies to qualify and meet lower conditions of participation for Medicare. Bottom line for you, they are a covered destination for ambulance services. So it'll probably get a H destination modifier for those of you in the billing sector, but it is a covered destination. Just wanted to make you all aware of that. So with that, here's our firm. Like I said, we're based in Pennsylvania, but we practice all over the place. And the 50th anniversary of this show just happened this weekend. What show is this? Emergency, right? The guy on the right there is one of the founding partners of our law firm. An interesting piece of trivia, he was a technical advisor for the show Emergency, worked hand in hand with Jack Webb, and was there on scene saying, no, this is how we would stage, this is how we would board the patient, etc. Who's the main character? Who was the heartthrob on Emergency? Johnny Gage, right? Jim Page was supposed to be Johnny Gage. They were actually going to name the paramedic James Page. And he said, nah, in case this thing goes south, I want you to change the name slightly to protect me. But anyway, sort of our claim to fame. Our collaboration with NEMSIS actually goes back years ago, back when they were first firing up and NEMSIS was in its nascent stages. They asked us to author an opinion because they were getting pushback and people were saying HIPAA prevents us from sharing information with the state agency or prevents the state agency from sharing our information with NEMSIS. So we wrote an opinion stating why not only can state agency or can the EMS agency share up to the state, but the state can then share with NEMSIS as well. So that started way back in 2007. And then it really flourished recently, right before the pandemic. I was down in DC at an interoperability conference and I saw Clay there. So many people were standing up in the middle of the conference and they're like, we never get hospital outcome data, right? And they're like, and they give us one word answer, HIPAA, right? That's their excuse for not giving us data. And I approached Clay and I said, I want to be the person who writes the paper. Our firm wants to be the firm that writes the paper that says they can give you outcome data. Not only is it permitted, but it's endorsed by federal agencies. One of the P's stands for portability of healthcare information. HIPAA is meant to facilitate transactions that fall within normal business operations. One of those being quality assurance
quality improvement. So if you've not looked up that resource, please avail yourself to that. We also put out some HIPAA basics for EMS practitioners, a little poster explaining what their duties are. And then we also did a paper on EMS body worn cameras and sort of legal issues that you need to consider. There are a lot of EMS agencies that are considering the implementation of body cameras. Yes, the implementation of body cameras. There's a whole host of legal considerations. So like in my state, in the state of Pennsylvania, I can't just slap cameras on everybody. Why? Law enforcement. So my party is one of 13 states that is a two-party consent state. That means everybody to the transaction has to agree to be recorded. So what that, then there's a carve out that they made for police in the state of Pennsylvania. That carve out does not apply to EMS. So if we want to implement body cameras in the state of Pennsylvania, we got to cross that barrier as well. So that's some of the issues that this paper talks about. This is the resource that is coming soon. This is what we're going to discuss today. So essentially, NEMSIS passed along to our firm a bunch of questions that they were getting. And we've researched these. We're coming up with compendiums of information from various states. And you're going to hear me mention this a lot today. It depends on state law. When it comes to medical records, typically an issue of state law. What that means is you're going to have to go back and reference your own state law. We're going to try to include some resource materials in this paper that'll give you a site to go back and look at your state law. But you might be saying, I'm going to talk about general principles here. You might be saying, well, that's not the way we do it in our state. It may not be, okay? When it comes to medical records, we'll tell you what, we're distilling this down as general rules. So let's do the lawyer stuff really quick. All right, here we go. Read that. All right, you guys ready for it? Right. It never gets old. This thing has been used for the last 20 years and people still laugh. So anyway, that's my only lawyer joke. This is copyrighted material. You're free to, disseminate this information, but, not give this presentation. And by the way, this is not formal legal advice. If you need formal legal advice, consult your attorney, or you can call us or any other able-bodied attorney that's on a billboard or a bus station stop or whatever, right? Better call Saul if you're in trouble. So first question, well, actually first category, and we grouped a couple of questions under this category. The legal status of a patient care report. Wow. All right, let's talk about it. Who owns the PCR data? Who owns it? Who? The agency. Anybody else? The patient. And depending on who you ask, you talk to patient right advocates, they're going to tell you the patient owns it. That's the patient's information. You talk to, the provider side, well, it's the EMS agency that owns it. Here's what you got to do. The law will either dictate or it won't dictate who owns the information. Here's what our research, and by the way, when we think of ownership in the traditional sense, so let's say I write a publication for our firm and we want to sell it, right? So that right of ownership, that belongs to PWW. I have the right to license that product. I have the right to say if anybody can amend it, change it, whatever, on down the line. The same is not true regarding patient care information in your patient care report. So, number one thing to remember is the medical record ownership is a matter of state, not federal law. You're not going to find a federal law that says who owns the information. And in our research, we found that a majority of states do not actually speak to medical record ownership. What they do require EMS agencies to do is do a PCR and keep it for X amount of years, okay? But it says nothing about ownership. There's 20 states that say that the records belong to physician or facility, some of those antiquated laws that are still in there. There are maybe a few out there that speak to ownership of ePCRs. We're going to still go through and determine whether or not there are any laws that pertain to that. Patients always have a right to their records, okay? The patient doesn't have a right to the original. Back when we were on paper records, agencies were calling us up and they're like, hey, the patient requested a copy of their record. We gave them the original record. No, don't give them the original record, okay? Patients always have a right to a copy of their record. It's typically going to be an electronic copy. Covered entities, those are EMS agencies, have to grant access to the patient within 30 days of a request. And the patient also has a right to request amendments and restrictions of uses and disclosures of their protected health information. Most of the time, agencies aren't required to agree to requested amendments and restrictions. If you have questions about that, see me after class and I'll talk to you about that, right? This is the one thing that I want to hammer home though. Ownership does not confer an exclusive right to control that information, right? If I author a product for Page Wolfberg and Worth, I control it. I can say where it goes. EMS agencies, guess what? Third parties can use their data as well. So they author the patient care report. We submit data to a regional office, maybe to a state EMS office, to facilities. Facilities can use your data to conduct their own QA/QI. So what was the outcome of the patient? Did we properly identify a STEMI when they came in? They can use your patient care report after the fact to determine whether or not there was a proper identification of that STEMI. And hopefully they're sharing the damn outcome data with you, because that's how we improve protocols, ladies and gentlemen. That's how we determine whether or not responding on scene faster, getting them to this particular facility makes a difference, clinical difference for the patient. Or, I don't want to get on a soapbox about the use of red lights and sirens and things like that, but we really need to get back to, does it make a clinical difference at the end of the day for the patient? So let me give you an example. Here's a state Department of Health. The department can use the data, collect and use to do system plans, evaluate the effectiveness of the statewide plan and regional plans in reducing morbidity and mortality. Point being, a lot of these agencies, they're tasked with very broad authority to use that data that they receive, okay? So general duties, EMS agencies, while it's in your possession, you got to retain it for X number of years, and we'll talk about data retention at the end here. You have to maintain it as outlined by HIPAA. If you're a Part 2 provider, which most EMS agencies are not, in accordance with that, there's also ADA rules that apply and any state laws that apply. Third parties that receive data, billing companies, EPCR vendors. You also, by the way, if you're a billing company or an EPCR vendor, if you maintain protected health information on behalf of your clients, you are covered under HIPAA. You're what's called a business associate. You're directly subject to the regulations of HIPAA. You have to maintain that information, do a risk analysis and all the other stuff that covered entities have to do. And they have to use and disclose and retain the information as permitted by law, any law that's applicable to them, and any agreement. There's an underlying agreement between those two. That's what data use agreements do, okay? So it's like this. I pass along data to another organization. They can do with it whatever the law says they can do with it, unless what? This is the United States of America, ladies and gentlemen. Guess what you can do? You can contract. You can contract for anything unless it's illegal. So if my cocaine dealer runs out on me, I can't enforce the contract with him, right? But here, if I want to limit the uses and disclosures of that third party more stringently than the law permits them to do information, I put it in a contract. I say, you, billing company, can use my data for the following purposes only. And guess what? We find out they're using the information outside of the scope of that contract, we sue them for breach of contract. So at the end of the day, we're kind of more long-term stewards than we are owners of that data. This is a good question. When does a document become a legal document? I get this from my paramedics. I teach a paramedic class at a local community college. And they always ask, well, when can I be held like legally responsible for this stuff, right? When's my ass on the line, and am I in trouble for what my partner did? I say facetiously, these are really good students who want to do the right thing, but they often want to know, when does it become a legal document? Folks, there is no magic moment where it becomes a legal document, okay? There's nothing really in the law that says, bing, it's a legal document. If I execute a sale of my home, once we record the deed, that's a legal document. If I contract with another party, the minute it's executed by both parties, that becomes a legal document. The minute I sign my will, that's a legal document. There's nothing that says that it magically becomes a legal document. That means any data can become legally relevant at any time. Meaning, if I'm a provider and I ran a call, suspected DUI driver's in the hospital, cop comes up to me, issues a subpoena for preliminary data. I haven't completed the run report yet. They say, I just want this information because I'm trying to get a search and seizure warrant for the car that the individual drove so we can search it. Can I get whatever data that you documented so far? Guess what? That's legally relevant information now that the cop can obtain. If it exists at the time of the legal request, most of the time it has to be produced, okay? If it exists, you generally have to give it over. There are exceptions to that, like peer reviewed documents and things like that. We had a question over here related to this. By the way, any documentation in your possession can become legal records. Yeah, question.
So I had a question from an agency about a year ago, which I don't know if we ever actually satisfactorily answered for their business office. They happen to be, I'm a state, Arizona. Okay. So we have a state system, but also we have an enterprise license where agencies can use it directly to enter their data. So we essentially become their repository.
Okay.
So the business office wanted to know they're required to retain documents for, I don't remember what it says in Arizona, for so many years, and if they're a minor, so many years.
Yep.
And they were advised by their legal counsel that if they still had access to those documents, they would be required to produce them if they didn't destroy them. But because we're the repository and we're a registry and we're public health, we don't ever destroy them. So I was trying to, I mean, I never figured it out. I'm like, do I need to deny them access after so many years? How do I make it, or now are they going to be legally responsible for the stuff that we're keeping? Because we don't want to dump our records after so many years.
Yeah, here's the short answer to that. If it's in your possession and you receive a subpoena with a court order, you have to produce it if you have it. If you never destroy that record, if you get a subpoena for something 30 years later, you would have to produce that record. By the way, that I'm talking about EMS agencies here, but that goes for anybody. If a billing company gets a subpoena for a PCR, they have to fulfill it if they have the record. If the EMS agency gets it. Now, if the EMS agency wants to get a heads up about any of those requests, they put it in their agreement, say, hey, any subpoenas that get issued to you, by and large, you are not allowed to ignore a subpoena if you have the relevant documents. The state laws permit very wide and broad discovery power for parties when they're in litigation. They say, okay, you can't get it from there, go here. Example, most of our data lives in a cloud for Apple, Google, AWS. AWS, Google, Apple, they get a crap ton of subpoena requests. And oftentimes they have to comply with those subpoena requests because they have the data. Now, that is subject to certain privacy laws, and laws are starting to catch up with that. So they're saying just by virtue of me parking data on a cloud doesn't mean it's all automatically subject to production. But bottom line, you look to who receives the request. If they have the document, they have to produce it. So let's say you're a state agency that has to keep it in perpetuity. So they issued the subpoena on the EMS agency and they destroyed it after 10 years. And this is 11 years later. They now issue the subpoena to the state agency. State agency must comply and produce that record in response to the subpoena. Yeah.
So at least right now in our state, we do not have to comply with subpoenas on our EMS data. We have some protected stuff in
Okay.
rules such.
The exception to that is if there's a state law that carves out an exception.
But how do we protect those kind of agencies where they're now worried about their liability because they have access to stuff that they no longer want to have access to? How do we, I in general, how do we, do you have any ideas?
Yeah, there's really no end run around there. Whoever's, the agency's lawyer would try to have to make an argument to say, no, the data retention requirement has already run to the MS agency. This should have been destroyed. And if that argument holds weight in court, perhaps. I mean, oftentimes this stuff's going to come up. Statute of limitations is usually 2 to 4 years in many states. Does usually take about 4 or 5 years till it gets into court. So, hopefully you won't see too many of those requests, but yeah, they would have access to the record later on. By the way, too, oftentimes agencies ask me, well, shouldn't we just destroy stuff as soon as we can? Sometimes yes, sometimes not. We'll talk about data retention and best practices in a little bit here. Yeah.
I just have one quick question. So if the subpoena comes to the agency.
Yep.
And the agency calls us because we have the historical information, specifically 2.0 and 3.0 changes, and now 2.0 is in a vault and they can't get to it anymore.
Yep.
Does the state, do they have to have a subpoena from them directly to the state to get that information?
Typically, yes. So they would have to amend the subpoena and subpoena the state. The subpoena is going to be specific to a party and it's going to be specific to certain information. We give an example. Oftentimes we'll receive a subpoena for a particular run date. Patient care report for April 19th, 2002 for Ryan Stark. If that's what the subpoena requests, that's all you give them. Sometimes subpoenas are very broad and they'll say any and all medical records that you have for Ryan Stark. That means they get every run that they've run on me, every PCR, they get every face sheet that they got from the hospital containing my information and any other information that they got from a facility or any other partner. would fall under that subpoena. It goes to the language of the subpoena, which is why it's real important, if you're not sure with a subpoena, is to ask your lawyer, okay? Ask them what you have to produce. And if you say, oh, I don't have the record, I've had clients come up with that all the time. Hey, we just don't have the record. We don't have access to the record. So that's sometimes our response to the subpoenas. We don't have access to it. Oftentimes the lawyer will ask about if there's another repository.
I'm sorry.
Yeah.
If the agency gets subpoenaed for a hearing, but they're not necessarily subpoenaed for the run form, but the agency is asking us for access to the run form because they want prep for it, that's a different situation, correct?
Yeah, could be. And if they're not asking in that, there's a subpoena ducis tecum where it's bring the body or bring the paperwork and the body, whatever. You got to look to the language of the subpoena to see what it requests. So if I'm a lawyer and I want them to bring the run report, I better say it in the subpoena. Yep. So there's a whole host of reasons why we get legal requests. And like I said, there's government audits going on all the time, civil and criminal cases, administrative reviews. One of the exceptions to subpoena power is peer review. If later on during a peer review, you create material concerning a run or concerning a mishap, et cetera, that information generally is not discoverable in a court of law. And there's a reason behind that. We want to fix the stuff that we're doing wrong. We don't want to penalize people and have liability for what happened in peer review, but you have to be following your peer review statute. That can't just be like, hey man, you really screwed this up and that was my supervisor talking to me. That ain't peer review, okay? So information in the PCR is generally open for discussion. So about legal requests, most of the time it's the final patient care report that we see that's going to be requested. We also think there are other reasons why something would become official. Signing a PCR has legal significance for the practitioner and the agency. It's attesting that you read the PCR, you're attesting to the care that you provided, okay? Billing a claim also has legal significance for the agency and the provider. When you submit and click that form, you're attesting to everything in section 15 of Medicare's form. You're saying, I hereby attest that we are compliant with any and all applicable local, state, and federal laws. That means if the EMS provider that went on the call did not renew their CPR certification, they were out of compliance with state law. Guess what? You don't get paid for that when you bill it to Medicare. So you're attesting that as well. Providers often ask, well, man, if I sign that run report, am I responsible for everything? No. We will apportion liability where it belongs. When the provider's in court, well, you signed the report, right? And I'm going to get up and rehab my client and say, yeah, but you did not provide the care. That's why it needs to be crystal clear who did the intervention, who did the assessments, et cetera. It needs to be very clear so that we can apportion liability where it belongs if there is any liability. So actions or omissions that are attributable to you as the provider. Just because you signed it doesn't mean you're responsible for all the actions and inactions of your partner. It does mean, however, that you read it. Okay? Because if I get somebody on the stand, you say, well, I was just a driver that day and I just signed off on it. You mean you signed a document and didn't even bother to read it? That's great fodder for a lawyer in closing argument. Ladies and gentlemen, we have a provider here who just signed stuff and doesn't even read it. How good of a job do you think they would have done that day? Question over here?
Yeah, you hit a very interesting topic. Actually, I just got yesterday is there are some billing companies that require 2 signatures on the ePCR. One, basically from both people who are attending with the patient. And so you bring an interesting point because if the driver, regardless if they're the EMT or paramedic, has no primary patient contact, but yet
they're not held responsible for what occurred with the patient.
Okay.
I'll tell you the reason behind that requirement. It's a Medicare requirement. Basically, it says that any and all providers need to attest to the care that they provided. Medicare right now is still, except for ET3 participants and limited exceptions, a transportation-only benefit. Meaning if we loaded the patient in the back of the ambulance and we did nothing for the patient except maybe take a set of vitals, the fact that we transported them, we're getting paid. That means driving the ambulance is a crucial and critical part to reimbursement of Medicare. That's why we ask both. That's why we ask for 2 signatures. And by the way, there are some state laws that require that as well. Best practices here, obviously it needs to be truthful and accurate whenever authored. Review them before submissions. This is the one thing I tell providers. you will keep your butt out of so much trouble is after you write it, read it, right? So many times we're reviewing run reports and you see like patients A&O ×4, GCS of 15, and then in the narratives, patient is very confused, doesn't know the date, like just so many inconsistencies. After you write it, read it. And any incomplete documentation should be amended. So that's legal record. What about official record? Same deal. States have certain requirements, and publish certain elements. Here are the things that we think make it more of an official document, whatever the heck that means. Satisfying any local or state requirements for required data in that ePCR, completion and conformance with the agency's policy, signing it. Definitely, there's some officialness or officiality, whatever the word is there, and billing that PCR. Again, you're attesting to compliance with all those rules. Is there a specific definition of a closed PCR? Okay. When is the document closed? Not in the law, there's not, or typically not. There may be sub-regulatory guidance that agencies have issued concerning, when PCRs are closed. Generally, when we talk about closed, it's a term of art that we use, right? It's generally when the EMS practitioner has completed all his mandatory fields and it passes it on to the next level, whether that be QA/QI or it goes up to billing. Many agencies, it's the point where it's locked out and it's got to be reopened by an administrator. So I go on a run. Typically, I get a certain period of time where I have access to the run, after which that locks out. So that's what we typically mean by closed. It really depends on the agency's policy, is what we mean by closed. So, and by the way, here's a law in Pennsylvania that says reports shall be made by completing the ePCR within the time prescribed by the agency's written policies, no later than 72 hours. What does that mean? If my agency has a policy that says we require completion of the patient care report at the end of shift, despite the fact that that's prior to 72 hours, they have to complete it at the end of shift. And if they don't, they're in violation of the agency's policy and they're in violation of Pennsylvania state law, meaning the Pennsylvania State Department of Health can actually issue disciplinary action against that individual in addition to their employer, the EMS agency. Okay. Best practices. If a state law does speak to requirements in terms of timeliness, that is the baseline. Okay. If my law says no later than 72 hours, I better not have a policy that permits a provider to do it later. Okay. There's some exceptions there. Like I get it. And they do make exceptions for, hey, we had a really busy day, et cetera, et cetera. But by and large, I don't want a provider being on the stand being like, so do you know what the legal requirement for completion of patient care reports is in the state? Which, by the way, many states have a 24-hour requirement. Yes, sir, it's 24 hours. And when did you complete this run report? It says Wednesday at 10:10. Wow, Wednesday at 10:10, approximately 72 hours after your transport. Yep. Now I'm going to go to closing and be like, ladies and gentlemen of the jury, this provider offered a patient care report days after they ran on this patient. I don't know about you, but I can't remember what happened yesterday at that NEMSIS conference. So how is this provider going to recall with accuracy what they did for this patient? And by the way, they did it in violation of the law. Their state law requires within completion with 24 hours. And there's a reason for that. It's because we forget stuff. It becomes unreliable. That's why states have requirements. That's why this report is unreliable. And that's why you should trust nothing that's in it, right? That's what the lawyer is going to say. So let's talk about amending PCRs. First and foremost, you have a legal and ethical duty to amend your PCRs. Anytime we notice incomplete, inaccurate information, should be amended. We also have an ethical duty to the patient, okay? We're dealing with patients that are often elderly, and if they get a bill because we did a shoddy job at our documentation, now it's billable since patient pay, we're violating our ethical duty to the patient. In an ideal world, the patient, the only interaction would be that interaction at the time of care. We wouldn't have to go back to the patient and fight with their insurance to get paid and things of that nature. Not only that, you have an ethical duty as an EMS provider to ensure that everybody else has an accurate and appropriate record. You are the only provider with the golden opportunity to see the patient at or very near the time of the injury. I know whether or not that fall was down a set of stairs, and I know what the stairwell looked like. But if I just document fall, they could have fallen from a standing position. Now the hospital's thinking patient's fine now, exhibiting no symptoms. Meanwhile, the patient could have a subdural hematoma because really what happened is they fell off of the ledge and hit their head. So there's a legal and an ethical duty. And by the way, we were talking about this at lunch yesterday. It is fraud. Fraud. You can tell your providers it's fraud to make shit up in your run report. Okay. Pardon the French, but that's one of the first things I tell providers. Don't make shit up. Always tell the truth and always do what's right for your patient. If you make stuff up, falsify information, misrepresent the patient's condition, or if I just check the right boxes to get through the EPCR application, that could be fraud. If it's billed to a federal payer, the EMS agency's on the line, and the practitioner can individually be in trouble for that fraud. So always accurate information. When, who, and how can it be amended? When? Obviously, as soon as we discover the deficiency, okay? And the sooner the better. As we said, memory stayed, okay? So, in court, they will say it's been X amount of days where they made this entry to it. They're unreliable in court, and delayed entries are given less weight by Medicare reviewers as well. They will often say after a certain period of time, give it less weight. So that means as soon as possible. I learned this the hard way. My client learned this the hard way a couple of years ago. Their record got subpoenaed a year after the event. Turns out the documentation was pretty bad. They looked at the run report and said, we better add more detail to make this look good, because there's going to be a bunch of lawyers here tomorrow for the deposition, right? So I show up, look at the documentation, and I see that there's an amendment been made. And I'm like, when was this amendment made? Oh, it was the day we got the subpoena. Ladies and gentlemen, every patient care report comes with an audit log. They're going to see when that amendment was made. What does that look like in court? Trying to cover stuff up. Even if we did the right thing for the patient, that looks bad for us. Ladies and gentlemen, they wouldn't have amended that report unless they had something to hide, right? Who should do it? The caregiver who wrote the documentation should amend the patient care and clinical information, okay? Minor demographic stuff can be made by others. Yeah, I'll repeat your question. Go ahead.
They give us a list of agencies that now need to go back and correct those. What's an appropriate amendment period? Because we were just talking about this. If they have to go back and change 2,000 runs, are they going to remember all those? So what's the appropriate?
So if it's clinical information that they're amending, like if they don't remember it, then we're not going to make the provider make that amendment. If they do remember it, there is no set time. There's generally no set time for which we can go back. I mean, obviously, as I said, the longer in time, the less reliable it becomes, but there's typically no cutoff point. If we know there are omissions there, we should go back. Minor amendments to demographic stuff can be made by billing officers. So we have a couple of questions over here. Yeah.
Paper runs. And then they is so the legal ramifications of that.
We're going to talk about that. In fact, I have a question that talks about what if we hire a third party to transfer our paper to electronic? I'll ask you to hold your question.
Thanks.
This is called foreshadowing. I actually paid you to plant that question to make me look good. Yeah, back here.
Going back to a little bit of previous topic here, you said Chip Cooper is asking if a state does not define a duration to hold the records, what's the recommended time to hold the records and why?
We'll get to that. That was another foreshadowing question. We're going to get to record retention in about 15 slides, so we will be there. Thanks, Chip. All right. Obviously, follow your state rules. If they say the EMS provider who assumes primary responsibility, which is what it says in my home state, they should complete the EPCR. Those are the individuals who should be going back and making the amendments as well. There may be circumstances where you have staff turnover and that individual is no longer there. We can't amend something that we can't attest to, okay? So if the other provider can't attest to what happened, we're not going to be able to amend in those cases. Here's what Medicare says too, and we care about what Medicare says because they're our biggest payer, oftentimes 60% of our payment claims. Amendment should identify the amendment as such, clearly indicate the date and author, and clearly identify original content without deletion of the original content. Okay, we're not going back and, in the days of white out and whiting it out and writing it over. What they say regarding amending electronic records, distinctly identifying amendment, provide a reliable means to clearly identify the original content, modified content. That means when we go into the report, we're going into the amendment feature for the report. We're not unlocking the original report and altering that. So they need to include the following information. And this is typically going to be tracked in your EPCR software. What about if a crew member completes, signs, and locks the report and information is added by someone else afterwards? Is that crew member responsible for those additions? What do you think? Whoops. Generally not, okay? Unless somebody went back, let's say they caught it in QA/QI and they went back and they said, hey, you didn't document how you guys transferred the patient, what the patient looked like upon arrival, et cetera. If they go back and change that information, at the direction of them, or if they're asked to review and approve the amendment, there is some responsibility when you actually go back and approve, but generally not. But they are also responsible and should be accountable for their incomplete and incorrect entries. So when we go back to them, we need to make clear what the deficiency was. If the EMS agency made the amendment, they would be responsible for it. And others should not change the original unless there's a compelling reason, okay, other than the clinical provider. And in some systems, it actually creates a PDF. So after they click submit, it'll create a PDF document. Generally, Medicare wants to see that additions after that go in as an amendment. Should a billing company be allowed to alter clinical information? No. They should only be able to change demographic type information if it's clearly missing, wrong, et cetera. Maybe they selected the wrong facility and it's very clear from the documentation, but only when the billing company is clear about that information as well. The implications here, if they change anything in the record, like let's say they change, they click a button that says the patient was bed confined. Well, we know that Medicare pays for ambulance transports when the patient's bed confined. That's now a false claim. If that's not what is supported in the patient care report, it's not what, billing puts on there. They can be liable under the False Claims Act as well. So for those billing companies in this room, if you do make changes to the record outside of demographic stuff, you can be held responsible for those changes. And watch for communications between billings and operations. What do I mean by that? If you're a biller, don't go back to the person and say, hey, listen, we need you to document here that the patient was bed confined. Clearly, the PCS says the patient was bed confined. That's fraud. You know what the one thing that it gets everybody? Freaking emails, man. They will get that email and they'll be like, look at this email from the biller to the provider. Document that they're bed confined. Wow, how many times have you done that? That would be Exhibit A in a fraud case. When you go back, you say, hey, this did not include information about patients' activities of daily living, their bed confinement status, if they were or weren't, et cetera. Can you provide more information that you remember? Are there any concerns with the QA/QI committee altering clinical information? Yeah, that should be sent back to the provider. By the way, that reinforces accountability. Can you imagine that? We'll just fix your, QA/QI. I've heard that. I go to agencies all the time and I do compliance site reviews. And you know where I find the juicy stuff? In the morning, we sit with the CEO and the president and everybody else. In the afternoon, I say, just drop me off at a bunch of stations and I'm going to take calls with those guys. And I'll ask them about like documentation, things like that. And they'll be like, oh, QA/QI always fixes that for us. And then I'll have a discussion with the agency about that, about what's occurring. And sometimes it's like, oh crap, we didn't even know that was happening here. It should be sent back to the provider. If a state agency is doing quality improvement work, this kind of gets back to question over here, and there's a data element missing. Can they go back and update it? Yes, but they should do it through an amendment, original practitioner whenever possible, and should include the time, date, and author and reason. And I'm going a little fast, but I have a lot of information. I want to impart all this to you guys. But if there are questions, we can stop. Should EPCR software providers have the ability to track changes? Absolutely. This is the regulation. This requirement applies to you as an EPCR vendor. It also applies to billing companies because you are business associates. What it requires are audit controls. You have to have the ability to go back and retrieve information about who touched the record and what they did with the record. And by the way, there was a proposed rule, it was way back in 2011, they retracted it, but at some point it could see the light of day if Congress or if CMS brings up the authority for it. What it would grant patients the right to get is an access report to their records from the previous 3 years was the proposed rule. And that access report would contain date of access, time of access, name of the person accessing it, a description of what information was accessed, and a description of the action of the user. Create, modify, access, or delete. This is not a current requirement. This is proposed, okay? I want to make that clear. But there may come a point where your software has to get down to that granular of detail. A couple of years ago, Jussie Smollett was admitted to a hospital in Chicago. He was an actor on a TV show, and they thought that he had feigned the incident. And lo and behold, a couple days later, the hospital, Northwestern, took a look at their record, and they looked at the access logs and audit reports from their record. 24 providers who had no business accessing that record accessed the record, and they saw it in the report. 24 providers lost their job that day. Let's talk about retention. How long do we got to keep it? So first, let's start with the feds. Is there a recommendation or requirement? No, there's not. Medicare regulations do say to maintain written orders. Written orders in EMS parlance would be physician certification statements, certificates of medical necessity that we get for generally non-emergency runs. But that's the only thing it says. I'm going to give you guys a hard and fast recommendation. Don't fret. We're just going through, because I need to prove to you, because everybody says, well, no, there's just one requirement. So we'll go through all these first. Whoops. Generally, state laws control further retention of the medical record. Typically, it's 7 to 10 years. That's a general barometer for EMS agencies. However, public agencies, municipalities, cities, counties, and hospitals even may have a different requirement. So if you're a hospital-based ambulance service, which there's a very small percentage of those out there, but there are a few hospital-based, you would follow the retention requirements for hospitals, okay? But typically 7 to 10 years. They usually apply to EMS agencies, not vendors or third parties. If an EMS agency wants its vendor or third party to retain records, it better make explicit in the contract what the retention requirements are. And typically the underlying agreement, it's got to come with a business associate agreement that will require the return or destruction of any and all protected health information unless it's infeasible at the termination of the agreement. So when we wrap up business with our organization, they work claims for a few more months, and they're supposed to either return or destroy, or if they retain that information, the protections of HIPAA remain for the length that the agency retains that information. Why would you as a third party maybe want to retain information? Well, if you're a third party biller, Medicare comes knocking 2 years later, and the EMS agency is pointing at the billing company for improper practices, you may want to be able to defend yourself in that action. So there might be valid reasons for doing that. So here's a couple of just examples. Here's our recommendation, all right? This is the important slide. When clients ask us, how long should we retain records? 10 years beyond date of service. Why is that? The Federal False Claims Act allows the government to go back as far as 10 years to prove a false claims action in certain limited circumstances. If it's a minor, okay, we're not talking about a person that works underground. If it's a person under the age of 18 at the time you transported them, you're going to retain for the length of the statute of limitations after reaching the age of majority. Let me explain this. So 10 years after the date of service, that's easy, okay? But if we transported somebody who was 10 years old, okay, we're going to keep for the longer of 10 years after the date of service or after the statute of limitations expires after they turn 18. Why is that? So let's say the patient got injured in the back of my ambulance. They were 10 years old. No claim was ever brought. Now they have residual injury stemming from that. Once they turn 18, they have the right to now sue me. And they're going to have between 2 and 4 years typically to bring that legal action. So I want to retain those records. If the statute of limitations is 4 years in my state, I want to retain it for bonus points till the patient is how old? 22. You guys are way better than I. Lawyers, we suck at math. Like I was just like, somebody help me out here. But you guys are all data people. So that's our recommendation. There are exceptions. If it's subject to litigation and audit, et cetera, there's a mandatory hold on those records and you may not destroy them. Or you might exclude it. Maybe it's a particularly bad event. Or there's another requirement in place. If you're a public agency, Typically, sometimes you have to retain, like she said, in perpetuity for those records. What about if they go out of business? What are the retention, custodial, and access duties? General rule, if the agency is purchased, merged, dissolved, etc., usually the records go to the purchaser or the surviving agency. If there is no purchase or merger, you gotta look to your state law. Our state law basically says contact the AG and come up with a plan. If you can find another provider in your service area that'll hold those records for you, more power to you. And then you charge them with keeping those records. Usually you got to find a way to securely store those records. Here are some general rules under your state laws. You got to comply typically with the state retention length and statute of limitations, okay? So if it says we got to retain records for 7 years, we better find a way to retain those records for 7 years. We might be able to park it on a secure cloud. You know, it all depends. A lot of state health departments and licensing authorities govern closures, and you got to give them a heads up. And when you give them that heads up that you're going out of business, not only are they going to ask you, well, who's going to fill in? How are you going to dissolve business? When are you going to go out of business? Is what's your plan for giving patients access to their records after the fact? Because what if I'm a patient and I'm now trying to prove a negligence action, you know, motor vehicle accident, I'm trying to get my records. I better be able to get my records from somebody, right? And some states say transfer to another provider. In a few states, the state archive or health department will store those records on your behalf. Consider federal rules too. Remember, they can go back as far as 10 years. The fact that I dissolved my agency doesn't absolve me as a human being, as an individual, from liability under federal law under Federal False Claims Act. So I may want to retain those records for 10 years so I can defend myself in that action. And Medicare auditors can typically go back 6 years to prove those. By the way, the High-Tech Act, some of you may say, well, what about the sale of PHI? The High-Tech Act prevented the sale of PHI generally without permission from the patient. There's a couple exceptions carved out to that. One of those is activities related to the sale, transfer, merger, consolidation, meaning you can make it part of the sales transaction. Best practices for closure. If it's a merger or sale, include it in the transaction, okay? So they can take custody of those records. And by the way, once another covered entity takes custody of those records, they, as a separate and independent covered entity, have to follow HIPAA just like you did with respect to those records. Meaning now that it's in their possession, they got to grant the right of access, you know, the right to request amendment, all of that stuff, and they got to comply with the security rules. Patients should be notified, and in some states, there's a requirement that patients be notified and be able to request a copy of their records. And by the way, if we're going to close up, if we got a bunch of records that are in backstacks, you know, I go to EMS agencies and I do HIPAA site visits, and I love like the banker boxes in a garage or something. And I'm like, how old are these records? You know? And well, this was one from Elvis, right? So get rid of those records that are beyond the date of retention. Don't burden yourself more than you have to. So this is the time to follow that destruction policy. And contact your malpractice insurer as well. Hey, by the way, how long are you going to cover me? How long do I have to retain records? So get their advice on record retention requirements. Is the retention length the same for EMS and state agencies? Not necessarily. Typically, state agencies are subject to whatever public agency laws. Yes, Rob.
Yeah, just, oh, wow, this is loud. So here's just going back one slide, but just say, for example, and let's invent some ambulance companies, AMR take over from Falk, or Falk take over from AMR in a market, and there's litigation that subsequently pops up. Who's on the hook for it?
Who's on the hook for it? So if they bring an action, it depends on the bill of sale. So if it's just an asset purchase, potentially whoever the principals were from the original organization who went out of business could have liability, and the individuals who perpetrated those actions could potentially have individual liability. If it's a different type of transaction, we're buying, you know, stocks and everything else. It all depends on the documents. So you can, if we're buying everything and all the records and everything else, some of that might come with some liability. So it all depends, and usually the contract will apportion that. Typically in a bill of sale, if I'm buying another ambulance service, I'm going to include in that sale transaction, they will indemnify me and hold me harmless for any and all actions and inactions that are attributable to the other organization, right? So let's say I get sued now and I get brought into court, they don't excuse me. I can go back and use that contract to go back and be made whole as a result of the actions or interactions of that non-surviving party, okay? And like I said, like for civil suits and things like that, you can bring a civil suit against the provider at any point if, you know, there was an assault and battery, et cetera. Providers are generally protected by Good Samaritan statutes, things of that nature, but they can be sued civilly as well. Is the record retention length the same for EMS and state agencies? And like I said, not necessarily. A lot of state agencies have to keep for longer, 10 years or longer. What about access to the data? Who can request a PCR and who should be in charge of those records requests? Okay, good question. First of all, there's a whole host of folks who can request records. We know that patients can. Health oversight agencies have the ability in their oversight capacity to request records. Payers often ask to substantiate the underlying claim, they ask for records. We get them from law enforcement attorneys, anybody with a legal right to request that records. Who should handle it? Generally, it's the EMS agency that's going to be the central repository for those records, okay? Generally, it's going to be the EMS agency. By the way, you can task a third party with fulfilling those requests. So if I say, hey, billing company, I want you to handle any requests for access to patient information, and I include that in a contract, I can do that. But who's ultimately on the hook if my billing company gets a request and they don't fulfill it? I am. Now, the billing company would be in trouble under the contract with me, but the agency, who is the covered entity, bears ultimate responsibility. And by the way, we talked about this already. Third parties have to fulfill requests when they get subpoenas for those. So if I'm the billing company, if I'm within possession of a patient care report and it's specific enough to request that document that's in my possession, typically I have to produce it. What about body cam videos or other type of records outside of the PCR? Again, you're going to have to look to what your state law defines as what becomes part of the patient care report. Some of it's very clear and it's only documentation that's authored by the providers within a certain period of time after care. Some of it is any and all digital and, you know, video or other information that's captured about the patient. By the way, HIPAA defines a record or a designated record set as any information that was used for treatment or payment. So if that information was used by your agency to treat the patient or to get payment for it, generally becomes part of your designated record set that the patient has access to. And the ability to request that type of information really depends on the language of the subpoena. By the way, we did a paper on legal issues related to body cameras. I'm going to reference that. And it talks about these types of requests and your duty to fulfill subpoenas and other things. So two just sort of one-off questions. Go ahead, Jay. We're doing well. We're right on schedule.
One, you're absolutely awesome. I got a question for you. I've been trying to find a definition of what a complete and accurate patient care report is, and I'm not able to find that. However, our attorneys are really good at answering. We can tell you what it isn't. Do you have any guidance, or do you have anything that say what is complete and accurate patient care report?
It's kind of what we talked about earlier. It's definitely fulfillment of all of the required data fields for state purposes. Then it's in accordance with whatever protocols, local and state protocols that apply with respect to documentation. They will often speak to patient care documentation. At a minimum, that's what it's got to require. As your attorney, I'd say as much information as you can give me, right? So there's really no hard and fast definition there, but generally your baseline is going to be required data elements satisfied, any protocols satisfied, and we're satisfying our policy would be complete and accurate.
We're kind of safe with that. We can tell you what it isn't when we see the report then.
Yeah.
Okay.
Are there any concerns when an agency or third party transfers paper to an electronic patient care report? Yeah. I mean, there's concern. Have you seen the handwriting of some of your providers? If you've ever seen written run reports, right? So there's concerns with the accuracy. Can they decipher the information? What about the timeliness? It better be within the state law requirement, right? And completeness as well. And what becomes part of the record? You know, if they made notes outside of the paper run report, you're gonna have to have a policy as to whether or not that becomes part of the record. Third party should not be authoring the patient care report. They should simply be transcribing what was already documented by the provider who observed those actions or inactions. And it can really lead to poor documentation if you don't properly utilize that party. If we see them constantly correcting things, reading things between the lines, et cetera, and going back to providers and leading them to a certain conclusion, that's bad. Best practices, the EMS agency should maintain the original written stuff from the providers, but they can digitize it, okay? Electronic copies are just as good as paper copies. So you scan them in, you store them on a server, a secure server, and you encrypt them. And the practitioner must still review and sign that patient care report and make any corrections or omissions that they see. Here's best practices. Use a third party that's familiar with EMS. Why? There are so many freaking acronyms, and other shorthand that our providers use. Your agents, whoever you use, ought to be at least semi-familiar, or the people that are going to be transcribing those claims ought to be familiar with what we're using. If we use common abbreviations within our agency, we provide it to them. We also provide them our dispatch protocols, our clinical protocols, a list of our current staff and all their credentials. And whenever we're transmitting information back and forth, that's a secure data transfer, okay? So that is an encrypted transaction. Does a third party need to sign the PCR? No, okay? It should be tracked that a third party, had a say in that, but ultimately it goes back to the provider to sign and attest to all of that information. Final question here. If an EMS agency takes patient identifiers from their EMS data systems, so they remove EMS identifiers, and they get the HIE to send outcome data back, so we're sending de-identified data to the HIE, and the HIE in turn, lo and behold, sends us outcome data back, do they fall into the same protections? Well, when we talk about de-identifying data, it's a very clear term. So HIPAA says there's two ways to de-identify it. Number one, you get a statistical expert to say it's de-identified. Number two, you remove 18 specific identifiers. One of the very specific ones being any geographic identifiers smaller than a state have to be removed in order for it to be de-identified. So that means removing all those. It also means, under the safe harbor, removal of all and no actual knowledge that the residual information can identify the individual. So can I just have one more minute? Okay. If you de-identify it, HIPAA does not apply to that data anymore. Any de-identified data no longer engenders the protection or any status under HIPAA. It might still be subject to a state law if the definition of PII, personally identifiable information, is broader, or there's the GDPR. Most agencies are not subject to the GDPR, but there are some agencies who practice in the EU and other places that are subject to the GDPR. So it may be a personal record. What about that outcome data that's coming back? That engenders the same protection. If it's identifiable, it's going to engender the same protections under HIPAA. It's also going to be subject to your state laws that speak to PII, and it's got to be protected in the same manner as your ePCR data. And it may have to be produced pursuant to a subpoena. Once I get it back and it's in my possession, like I said, once I get a subpoena, I got to produce whatever I had, right? It's like Trump, when they went to his house, it wasn't like, tell us what you have. No, if it's there, it's there. You got to produce it. So with that, we are at the end point, and we wanted to give you guys, I'm going to be here for a while. Oh, do you want me to handle any questions, or we're going to checkout time right here. So we want to give you guys adequate time.
If you're willing, Ryan, we'll pick up after break.
Okay.
Questions, if that's okay with you.
Yeah, if you guys have any questions, and like I said, I'll be around the rest of the day. So go check out, and we'll see you back here in a half hour.
Yep, 30 minutes.
Okay. Thank you.
Inviting everybody back to their chairs. I apologize to have to cut what I'm sure the interesting conversations and the connections that we're trying to encourage while we're here at this conference. Live again, back in the seats, back live. Everybody, we came back and we're all back together again. Isn't that wonderful? Thank you so much. Okay, so we've got a couple of things that we have to get done here before we move into the next exciting and informative presentation. We have 2 more prizes to give away on the prize wheel, so let's get started with that. You know how the prize wheel works. Everybody is on the board here. We're going to spin it around. We've got one. We're going to hand it out to Chris Conway. Chris Conway, live or online? Not in the room, apparently. He's virtual. Okay, everybody, big round of applause for Chris Conway. We will get your prize package out to you in the mail. So we'll take him off the list. One more spin. It could be you. This is Schrodinger's wheel of prizes. It's everybody and nobody at the moment. But for real, it's actually going to be Peggy Huddleston, excuse me. She is online, so I promise this was random. It's not just the online people because they're the people that I'm paying attention to this year. Okay, so one more thing that we need to take care of here. So yesterday I kind of explained what the that we had. Okay, first let me start off with this again. We appreciate everybody's hard work in here, all the work that you guys do for us and with us. But there were a few people over this year that had gone above and beyond. And so based off of a offhanded remark that Ben is probably more embarrassed about that he's mentioned now and regretting, that he said that we should have an award that we hand out during the live meeting that we jokingly called the NEMI Award. I believe at some point we were going to change it, but every time it came up for discussion, like, what should we call the NEMI Award? We just got all used to it. And so that's what it is. So, but yesterday we still had one more NEMI that we wanted to hand out. So I'm going to go ahead and hand the mic over to Lori on stage. This is live stuff. And so they can explain the wonderful things that this person has done to earn the NEMI Award.
Thank you, Chris. It's been a long 3 days, huh? That's okay. That's okay. All right, we did just read this description the other day, but the person was out of the room, so I wanted to read it again and invite him up to receive his award. And this is for a state that we are grateful. It's actually a new state data manager who's new in his role within the last year, but he worked really diligently. And as soon as he came on, he really wanted to bring his state up to speed and start submitting version 3.4 records, and was able to do that pretty quickly. And so we want to bring up Jim Adair and say thank you for your perseverance and dedication to EMS data and for all you do.
Thank you.
And then I'm going to switch to this screen. All right, next up, we are going to give prizes for the scavenger hunt last night. Thank you so much for everyone who participated. I think fun was had by all. And let me give a quick shout out too. If you need proof of participation in this event, there's some certificates we printed on the table out there. They should be sort of alphabetical by last name if you want to grab that on your way out today. And we had a great turnout. I think we had 7 teams participate, and it ended up being about 30, 35 people that participated in the scavenger hunt. And we have some prizes. Let me show some pictures first. I was questioning if I really should have shared my cell phone number with everyone last night, as I was getting 43 texts from Jay of what play-by-play of what their team was doing, and lots of pictures being sent to me. But here's some of the highlights from the different teams. And if you were not there, they had items that they had to try to find, and then they got more points if they had a picture with their whole team in the picture with that item. And so there's some, and we'll share these, I'm sure, online, social media, or maybe on a V3 call in the future too. But here's some more. The porta potty had moved, I heard. There was one on Main Street that disappeared. So someone asked the shuttle driver to pull over on the side of the road and let them get a picture by the porta potty on the way back. So that was fun. And we actually had, I was very impressed by this, but we had 4 teams. We originally had 3 prizes, and I had to put together another prize this morning. We had 4 teams that found all 30 items, and I'm taking their word for it slightly, but they tell me that they had their whole group in each picture of those items.
And there was one question. I know Keenan was looking at Jay's picture and told me that Jay was not in this picture, but we saw his reflection in the window. And so we counted that picture, Jay. So here are the winning teams. Let's give everyone a round of applause. And if you can have one person, maybe kind of a leader of your team, see Benji. We have gift baskets that have the appropriate number of items in each basket based on how many people were in your team. So everyone gets something to take home. And I think that was all I need to do. Are we going to do questions with Ryan next, I think? You're welcome. Glad you enjoyed it. Yeah.
I'll just, while she's taking pictures, I just somebody came up over the break and they were like, what do we need to, where does all this liability emanate and where does it start? Where do most of the issues originate? It really originates with our providers, right? At the front level, it's garbage in, garbage out, to the extent that we can do our jobs, harvest good data, bill for things, it becomes a function of the folks that are originating that data. So what that means is that organizations that haven't done so, you shouldn't just assume that the provider, has gotten adequate and formal training on writing a good narrative, good clinical narrative, and doing good documentation and the legal ramifications for doing documentation. So that should definitely be part of your onboarding process. And it should be ingrained in the culture of your organization, just like you wouldn't tolerate deviation from a protocol for, administration of medication or something like that, or acting outside of the scope. Documentation should be, compliance with documentation standards should be fostered in the same way. And we should QA/QI things, for completion, accurateness, things like that. Some of the things I've seen agencies do, I was at an agency recently, they do a bill along program. So the billing's in-house at this particular agency. All the billers go on a ride with the providers and ride along. And then the providers in turn are actually required to sit in the billing office for 2 days a year. And they go over their runs and they have somebody stress the importance of that documentation. Because once you see that it affects somebody down the chain, especially if it's within your organization, that has an impact. The other thing that I really can't stress enough too is positive reinforcement. I know it sounds like touchy-feely stuff, but if you start getting good run reports, you see improvements in documentation, you absolutely need to go back to your providers and say, this is outstanding. This is exactly what we want to see. Your compliance with, your signature compliance rate have skyrocketed. That's amazing. That positive reinforcement will get you so much more at the end of the day. I'll open it up for any residual questions. I'll give you my email address. It's rstark, RSTARK @pwwemslaw.com. So you can reach out to me independently of this, or if you have questions, obviously you can sign us up, as your firm as well. Any questions, any remaining questions? We will be sharing my slides, by the way. Yes. Yeah, so, the discussion about narratives, and you should be using definitely a consistent format. The format, we have one that we recommend. It's called DRAT, that we teach in our certified ambulance documentation specialist course. And it's a chronological story of what happened with the patient. The reason why we stress narrative so much is the reviewers who subsequently scrutinize our documentation, they're typically RNs, they're nurses and other healthcare professionals that are used to reading chart notes. So when we get in front of Medicare reviewers, they almost always exclusively look to that narrative. They say to us, well, we know that providers get lazy, they just check a bunch of boxes and get through the application. We need to see a good narrative. So recommendations are obviously use a consistent format and make sure everybody uses that same consistent format within your agency. So if you onboard somebody and they say, well, I always did SOAP there, you say, well, our format is this, if we believe that is the best format for it. We also typically recommend that it always be in chronological order. And like I said, you can Google DRAT. It has 2 R's and 2 T's in it. and you'll find articles that we've authored regarding that particular format. Got a lot of questions about auto-generated narratives, filling stuff in, things like that. It's our position that if it's auto-generated, that providers really got to go back and look through that narrative and scrutinize it, because we've seen auto-generated narratives that are just nonsensical and it's only as good as the data that are inputted. We would much prefer a provider take a few moments to recollect on the call and tell a good story from the encounter to the transfer of care. So from dispatch, how were you dispatched? How did you respond? What did the patient look like when you encountered them? What did you do for the patient on scene? What did you do for the patient in the back of the ambulance? And then when you transferred patient care, what was the patient's condition at that point? And how did that transfer occur? And who did the transfer go to? But clinical documentation is so important. You see providers, one of the other effective exercises you can do is we do a mock cross-examination where we'll have a provider pull their run report up and we'll play the role of the lawyer. And we'll scrutinize that documentation. Oh, what about here? Why didn't you document that here? Well, it was only a second set of vitals, wasn't a big deal. Oh, okay. Well, it turns out this patient went into cardiac arrest after you dropped him off at the hospital, so a lot of those exercises can be effective. And a lot of providers, I was just in a city recently and I was out with their providers and they said, you know what? They don't usually tell us what good documentation is. We haven't gotten proper instructions. So to some extent, if your agency has never shown these providers about what completeness looks like, what accurateness looks like, they need to be shown that type of information when they get, fully completed and accurate runs. Folks, this is what we mean. When you document pain, I don't know what the hell that means as somebody looking at that report, right? Pain to me is way different from pain to my grandmother and, et cetera. So I need OPQRST. Are we rating the pain, scaling the pain? So we need to show our providers and give them adequate, opportunities to be engaged in that. And really what it is, it's about setting the culture. Right when you onboard them, you say, look, folks, we expect and we require good documentation. You would also ask about what about like cutting and pasting narratives? That's a big no-no. There have been a lot of fraud cases brought on that very issue. They've noticed cut and paste narratives, cut and paste PCRs, and that's an easy one for them to prove fraud if it looks exactly the same for the last couple of patients. So that should never be performed. What's funny is my mom worked in an ophthalmologist office a couple of years ago. She's retired now, she's in South Carolina. And she told me that they did that the doctor told them to always cut and paste the chart and bill for the highest level. And I'm sitting there like getting antsy. I'm like, Mom, that's fraud. She's like, what does that mean? I'm like, that means like the doctor can go down for doing that. She's like, well, how do you get somebody in trouble for that? And I said, well, you got to become a whistleblower. She goes, maybe I should become a whistleblower. I'm like, no, you don't want to become a whistleblower, Mom, because generally you're the pariah. Or maybe she did, and that's why she's living in South Carolina now. She's under the witness protection program, right? So, because she goes by Mimi most of the time. Other questions? Like I said, I'll be around for a little while too, and you can email me as well. Over here, we'll wait for the mic to show up.
Yeah, so NEMSIS is an XML representation of a patient care report. And many times in systems, there's other data that's collected and reported, and whatever fits the NEMSIS standard can go out in that XML representation. And then it's got other stuff that the crew doesn't have to put in that NEMSIS supports, like the whole payment section, the outcomes section, which would come from a hospital. Some of the things that are most blank when they come to the national database are payment and outcomes, because that's not something the provider is going to put in. It's something that the biller or the hospital is going to provide down the road. Do we need to do anything about, I guess, policies or guidance or, things to say? I assume that if a patient care report was reviewed in a legal process, the legal process is smart enough to say these outcomes came from the hospital. The payment stuff came from billing.
Absolutely. Those other records will be ascribed to that provider. It's not like they get married up and it's like EMS did this. To answer your question, though, this really rests at the state level. I believe we have these really minimal definitions of what a completed PCR is. And if you look, they were really written at in the nascent stages of EMS when EMS first came out. What did we do back then? A trip ticket, right? You had to write up a trip ticket. And you need to look to see, data element requirements. If states start adopting and wholeheartedly adopt some of those recommended practices and pass those on down, whether it be through regulation or some sub-regulatory guidance, that would be very helpful. I think what a lot of these EMS agencies are doing is they're saying, we just want to give them the bare minimum. Let us comply with state law, and that's what we're going to get by with, because at the end of the day, they don't see it. There's this thing called cost data collection that's ongoing right now. You guys are probably familiar with this. CMS is collecting cost data from us. I was at a conference recently in Arkansas, and somebody asked the question of, hey, how many providers in this, or how many agencies in this room intend just not to do cost data collection? And a lot of hands went up. The penalty for that is a 10% reduction in all Medicare payments the subsequent year. So that's a pretty harsh penalty, but they were just like, it's too much for us. And that's a lot of times what they're saying with these things. So, and it all boils down to input. How can we make it, as streamlined as possible for the provider, but still collecting? There's a balance to be struck there, certainly. Yep.
The other part of this is I read their instructions. At my agency, and I looked at it and said, you must be hallucinating, was the first one. And second, these are not written for the average rural EMS agency leader who is thrilled to answer 12 calls a month. Medicare has unrealistic expectations and piss poor communication.
Agreed. Not much I could do there. Same thing when HIPAA first came out too, small providers were like, there's no way we can comply with all these mandates. And there is no small provider exception. Same thing with Medicare rules and regulations. Your documentation stands up to the same scrutiny as the large healthcare conglomerate. If you build a Medicare program, the only way out of that is to quit billing federal and state programs. Then you aren't subject to their requirements, but then you pretty much go out of business, as we know in this day and age. So yeah, unfortunately, there's not much leeway that is given there. They don't just take into account. Now, in a fraud and abuse investigation, if they're trying to come to a settlement amount, they'll take into account, the financial health of the provider when issuing fines and things of that nature. But generally, same documentation standards apply. Yes, we have an online question.
Yes, so from Karen Jacobson, we have from South Dakota. She says, Ryan, so when state EMS offices get pushback from EMS agencies regarding the number of elements they are required to touch, in quotes, enforced by data entry rules, can we use billing and fraud as the best reasons to complete the full report?
That's not the best reason. The best reason is because we owe it to the patients that we serve. Because at the end of the day, we'd still be doing mass trousers and longboarding patients and all that other stupid shit that has no evidence-based merit. Sorry for that. I swear it. When we do conferences, we swear. So sorry about that. With the censors on it. But bottom line, it's the best thing for the patient. That's how we improve standards. It's how we allocate resources. That's how we know we have a public health issue in a particular region, is by collecting that data. So that's the number one reason, is because it benefits. If you want, as a provider, to improve the level of care and improve, survival rate for out-of-hospital cardiac arrest, identification of STEMI, and other things for the folks in your community, that is the justification for providing this data, absolutely. But as an adjunct to that, oh, by the way, you can go to jail if it's not complete and accurate, things like that. I mean, not to the state agencies, but yeah, they can use, fraud, abuse, liability. Yep. Other questions? Okay. Oh, you have another online?
Okay. This is from Chip Cooper. As a cost benefit ratio and call demand, spending an hour on every narrative is unrealistic. What is the balance?
That's a good question. What is the balance there? You gotta hit the bad stuff, and you cannot tolerate the woefully deficient stuff. Some of this is going to be periodic training throughout the year. You're going to catch some of the stuff in the middle, and then reinforcing the really good stuff. But the woefully bad stuff, what you allow will continue within your agency, okay? If documentation is a skill like anything else, you know, I get providers who say, well, I'm just a really bad documenter. You can learn to be a better documenter, right? When I got out of law school, I didn't know how to write a complaint or any of that stuff, but I learned. So it's a teachable skill and it can be remedied by conducting periodic trainings. And that can be through outside parties as well. Sometimes nothing's more effective than having a lawyer come and tell your providers why it's so important and, you know, the critical aspects of good clinical documentation. So yeah, you can't spend a lot of time on every single run report. The really bad ones you're going to have to flag. And then with respect to the other stuff, it's going to be agency-wide training, you know, periodic training. But yeah, right. That's our pro bono division. You can call 555-555555. I'm kidding. And that brings up a good point too. Somebody approached me and they said, do you speak at? Yeah, we speak at a lot of functions, agencies, conferences. I'm going to Arizona Ambulance on Thursday. So if anybody ever wants us, any of our attorneys or consultants to come out and speak, we'd be more than happy to do that. So just reach out to us. So we good? Capiche? All right. Thank you, folks. Appreciate it. Hey, Benji, you can unmute your passcode. Sorry.
Okay, thank you, Ryan. Wow, great information. I learned a lot before the break and after the break in regards to those issues. So thank you very much. We have two more topics here before lunch. Both are important topics and both I assume will in conversations. So we're excited about that. So let's go in and dig in. So the first one we're going to talk about is an extension and continuation of a project that we began a couple of years ago. Josh led this work where we, the request was, and I don't remember where it came from, but the idea was, wow, there is now so much literature coming out using NEMSIS data, for example, looking at out-of-hospital cardiac arrest. We had a couple of investigators that reviewed that literature right as they're preparing to do a study or something, and they found that like the criteria differed slightly or differed a lot, right? So it was very difficult to compare in the literature one study about out-of-hospital cardiac arrest with another study out-of-hospital cardiac arrest, even though it was the same data, right? So so Josh took the lead on that project. He did a fantastic job, and we ended up developing some case definitions for research, right? So they can go to the website. If anybody wants to look at stroke, here's how we identify stroke patients. Here's a unified way of identifying stroke patients in NEMSIS. These cast wide nets, I think, and so they can certainly indicate that we use the criteria prescribed by NEMSIS and we limited it in this way. But at least it provided some real stability in regards to being able to compare research. And we've received a couple of additional requests as of recently, right?
Yeah.
Have you looked at those? Because it was just the last couple of days.
Yeah, no, not really.
Okay.
Yeah.
I know that one of them, it just came in right before the conference started. They came from the office of EMS. I think Eric was talking a little bit about them. I know one of them is related to mental health, right? Being yeah, as a mental and behavioral health coming up with a common definition. Well, we have forever talked about the idea of the value of having a defined list of ICD-10 codes, right? So now we want to talk, how can we continue this work and move this standardization of ideas or topics, conditions, impressions into our providers' hands, right? Because if you looked at the work that Josh did, all of the STEMI, the stroke, the car crashes by different types, It is a big group of variables that we had to include because there is real variability in what people are using. And there's value to that to an extent. For example, mental and behavioral health probably will be a wide set of codes for researchers. But maybe the other question is, with the idea of defined lists, can we come up with a cluster of ICD-10 codes that we can decide as an industry is important to capture mental and behavioral health and limit it to that? And I don't know, I was going to ask Ryan, one of the other questions I wanted to ask Ryan was when providers include codes, for example, for mental and behavioral health, that can only be diagnosed by a medical professional. If using that code is, well, it's probably not good practice, but I wonder if it had liability. So I think there's value in us deciding what codes will be used for what conditions. So one of the ideas, and I want to call on Jay, just to make sure that I'm describing this correctly, is that I think this the Data Managers Council within this NEMSO is going to organize a common definitions, case definitions, something work group that will be charged. One of the things they'll be charged with is what code do we want to use for these new scooters? What code do we want to use for, what cluster of codes can we use for a non-fatal opioid overdose instead of this many, right? So I guess the first question to you as states and as vendors is this idea of defined lists going to work out with your clients? Or how often to date have you said, hey, NEMSIS suggests this code, and you have a defiant medical director that says, no, I want to use this code? Any concerns about now really taking advantage of these defined lists, keeping them up to date, allowing those to be in a revision cycle or be added and sent out to you as states and vendors? So, yeah.
While the mic's getting over there, I wanted to add, I would propose that there's a little bit of a distinction between the data input side and the research side. The case definitions are the research side. It's very easy for us to say, hey, just take these 40 ICD-10 codes. Any patient care report that has one of those 40 codes, it's in for your research, right? And they run it on their batch of data, that's fine. And that's different than the data input side, where we have different purposes for coming up with defined lists. It's more about accuracy of EMS documentation, about the ease on the provider who's trying to find the right condition to record. You know, it's those kinds of considerations as opposed to the research side that's just, hey, we'll just grab all these codes, we're good with that. So kind of think about that.
I think we should keep in mind the diverse set of customers that we have, like customers, critical care customers. We should consider the diverse set of customers that we're serving and providers that we're serving. We frequently see people in the flight space, critical care space, transport, non-911 space that maybe do have a diagnosis that has come from a physician, or have a set of sets or a set of conditions or procedure, because I know this kind of grows into the standardized set procedures that are performed that are out of a scope of practice or something like that. And I want to be able to report that accurately and send that data to their billing departments and how they bill correctly and downstream.
Yeah, and I think the patterns will always be active, and that's a good point, Ken. I mean, we could come up, it would be much harder, but I mean, we could come up with a defined list for other types of EMS calls than a 911 risk, you know, ground response. But yeah, you're right. The pattern will always be available.
I need to make an announcement really quick.
Yeah.
If you are connected to the room internet and you don't need it right now, please disconnect. We're just having trouble getting enough bandwidth to be able to produce the virtual signal strong enough. Thank you.
Yeah, one over here. I just want to mirror Keenan over there, and
when we look at the defined lists, they were not written for the entire EMS organization.
That's
Our EMS includes BLS, paramedicine, critical care, and no, I don't, I don't want to speak for you, but our critical care organizations across the US are struggling with NEMSIS. They can't document weights under a kilogram. These lists are not user friendly for them. They're complaining. And they're like, what do? We have to maintain NEMSIS compliance because of the states, but we can't document our care because of these limitations. So I would encourage NEMSIS and data managers to maybe consider changing the defined list to maybe the 9-1 defined list, or be a little bit more specific. Or if we're going to adopt these defined lists, make sure they encompass the entire pre-hospital environment. The other thing too is, as we just when we think about COVID and we had to add those ICD-10 codes, when we think about defined lists, I would discourage anyone who builds schematron's rules limiting just to those lists in case we have, hopefully, not another pandemic or something comes up, because we added codes and all the vendors had codes immediately overnight. And if the schematron rules were in effect, those codes would not be submitted. So just kind of think about the ICD-10. The great thing about that is the ability to collect larger groups of data and meeting the whole kind of dynamic world of EMS.
Thank you. Great comments.
Yeah, I think similar. First, I want to say I love the idea of defined lists. Because it gets us using the same codes to talk about the same things, but also realistically acknowledge that it's probably going to be impossible for us to all use the exact same code list. And Josh, I think you touched on a really good point that we struggled with a lot when we were working on updating our defined lists for 3.5, this idea that we want a limited list of selections to tell our providers, here's how we want you to document those. However, if we're doing a research study, we'll also include all these other codes over here. So in essence, we're kind of contradicting ourselves and saying only submit these, but also we're going to look at these over here too. So I wonder if there's some differentiation between how we want to utilize them. What is the intention of the defined list? Because if we're doing research based off of it, but yet our research practices don't align with it, then it kind of feels conflicting. That makes sense at all, but we grappled a lot with that exact question you brought up.
Yeah, and I don't think you're conflicting by doing that, by giving your providers guidance about the codes that are most appropriate to use in the EMS environment. But on the research side, just pulling in all codes that are potentially in scope.
And that partially relates to also the different types of EMS, right? So if you wanted to collect all strokes or STEMIs, right, that you do have critical care and they're using a more, precise code based on, some other purpose. And maybe a stroke or a STEMI isn't a good example, but yeah, there will be the need to, yeah, but you're right. I think this will help a lot, right? Because if you look at, for example, what the state and territorial epidemiologists did to identify non-fatal opioid overdose, it's every influenza code, right?
Opioid? No, is it? But all those F codes.
Yes.
Yeah.
Yeah, so all the F codes. So just lots and lots of codes were used to identify that type of thing. So I think this will be helpful. Yeah. Mhm.
So, kind of like synthesizing what a lot of people are saying is like, it seems like having a restricted set of codes is probably not going to be the best, because you're always going to find someone who's going to say, I'd rather use this code. You can make like a recommended list and say, you can start with this list. This is our priority pieces that you should be using to start with. And if you have that medical director that needs to be, for whatever reason, using that code, that's different from there. And then you have the ability to use that range for the research as well. Having a limited list of recommended high priority codes, but then you can use more than that. I think that would restrict less and allow more of what everyone is kind of trying to say.
Yeah, and that's actually how it is used, and maybe a little bit of background for some of the newer folks. We came up with that defined list by taking several years of data that was submitted to NEMSIS and identifying and including on those lists. Julianne did all this just backbreaking work. I think we included, Julianne, any code that occurred more than any code We included all codes that represented 92%, greater than 90% of all the codes within that element, right? So primary impression. Yeah. So there are those that fall outside of the defined list. And so the patterns available. Yeah.
I think we had.
So I have a question. Sorry. This defined list would be, the whole idea of suggested and defined lists admittedly is a little bit lost on me. I kind of understand where you're coming from. But the defined list still seems to be a suggestion, which I like the idea of that, but the defined list is not being enforced through rules. Is that correct? And would that still be correct if we created this defined list?
Yes, and so defined lists are out, and we're the ones that began using the term suggested list because early on that was the approach. But we're trying to refine, and the idea now is their defined list. They're not required to be used because we expect some modifications across states, but I think states are agreeing to the idea that they will do their best to stick to the defined lists.
Okay.
Great. That's key. That is key. We'll take one more comment, then I want to get to this last item just real quick. Yeah, Jay.
Oh, you're gonna call me. Thank you.
Yeah.
Hey, I just want to say a couple things for the thoughts that's been brought to me as the lead in the Data Managers Council is one, we want to be sensitive. We want to be understanding this. We're trying to put this together. We know that we're just trying to come up with a basic list to help. And we also know that every state's going to have some modifications for that. I'll get laughed out the door if I put jellyfish stings into Wyoming on there. So I know that there's going to be some discrepancies. Kind of some of the premises that we're looking at a little bit. One, yeah, we've got the defined list. You guys are absolutely awesome. Hats off to you to work because depending on where you read, I'm just going to give a number that I've got. Like there's 60,000 codes in ICD-10 or something like that. Just a huge amount. But kind of the background premise is, you know, what's right for the patient, and then followed by what's right for the providers. Where can we find that delicate mesh to put in? And then one of the other things, some of you may have been there when we reported out to the state directors. And one of the concepts I think that's really going to help us is if we get a basic list, and we know that list isn't going to be perfect. And here's my scoop. I'm working in hospitals. I've consulted with different clinics, I've helped build some medical record systems and stuff like that. No medical record system is ever going to be done. And that's the one thing that we always pretty much have to remember. But when I reported out to the state directors, we put out, here's a concept for you. Can you imagine if we have some basic sets that get followed that do pretty good, and providers are trained in one part of the nation with that? When they move to other parts of the nation, imagine how much time you'll be able to save in training those people and moving to your location and just get to the intricacies in there. So I got a number of comments from state directors that that's not such a bad idea, that we're going to be able to help move people across the nation with some of these lists. We know the lists aren't perfect. The lists aren't perfect for a BLS ambulance service. The lists aren't perfect for an ALS service. The lists aren't perfect for the flight teams. But how close can we get to it? How much can we give and take? And yes, I mean, if you have some really rare disease or something like that, the text is available to write that in your impressions. Or our legal folks look at me and says, why can't they put in the list and then expand it in the narrative? And I'm kind of like, yeah, it's always available to them. So they kind of really like the concept of where we're at. So I just want you to know that's starting next month. The DMC is going to start meeting Tuesday, September 13th. And we're going to start hashing some of this stuff out. It is a massive project. So we're going to start putting some basics in. Where can we get the best bang for the buck, get off the ground? And then we'll see what we can do to do that. And thank you, Clay, and your groups offered to help with this. Josh, please know that you're invited also on that too, because you've done a lot of work in the background. Happy to answer any questions on the side or comments, thoughts. And I just tried to cover the highlights of what we're trying to help with.
Yeah, great. So we're, sort of stop. I'm gonna ask two more quick. Let's just extend this by 3 minutes and then, because it's the, we're gonna be talking about versioning before lunch, but just two more quick questions. One is, let's keep in mind that the defined lists, so these could be updated on a routine basis now across the country, which is just fantastic, right? If new codes come up that we need to add, this will be our mechanism for doing that. Also remember there are labels associated in those defined lists. There are labels that we would like to see on the presented before the provider, right? Not the definition of the code from ICD-10, right? We're all familiar with that. So any concerns about that? Those I think will be reviewed as well by this group. Yeah, Jay.
I was just going to say, it's been discussed a little bit. The terms, should we even be included? I'm not saying we're removing these yet or whatever. Should we even be including things like unspecified or NOS, not otherwise specified? That doesn't look the best in things. So I'm not knocking where we've been. We've got some growing pains. I think we're really heading in a good direction, and I'm hoping it's going to be beneficial. And we've got some super smart people and different people we're going to be putting that through. And yeah, we're always open to feedback. You can get a hold of any of the DMC members and talk to them. They'll be happy to feedback on that.
Fantastic. Yeah, and then just, yeah, Dan.
Yeah, just real quick, this touches a lot of parts of our application, and so this feels to me like it'd be if you're gonna add and change it down the road, a good candidate for like the annual minor release instead of just January 13th or July 10th. You know what I mean?
Yeah.
Okay.
Yep. Great. Yeah, great comment. All right, just one more minute. Sorry, Eric. Go ahead and have another cookie. I just one quick question here. So one of the other requests that we're hearing a lot about is this idea that a state or someone going to the NEMSIS website will pull up one of our dashboards and see some data related to a topic that doesn't match with what they're seeing in Continuum or what they're seeing in biospatial or what they're seeing in another source of data. Does it behoove us to have within our group a common, or at least as common as we can get, definition for opioid overdose? They're not going to match completely, because, for example, NEMSIS doesn't get narratives. I know lots of states or others use narrative, but does it behoove us to do a little bit of work here to try to ensure that what is seen in ZOL, what's seen in ESO, what's seen in Beyond Lucid, or in an image trend is as close to the same as possible?
If you do that, I would advise you to abandon ICD-10 codes altogether. Seriously.
Yeah.
Because
so
it's
thanks for the idea.
We've done some data from system to system, and with these descriptions, you get the weirdest result. And like you're saying, in Continuum, in biospatial, you have the ICD-10 codes, right?
Yeah, we do. And so this may help some. We have to stick with ICD-10 if we want to remain an ANSI standard, so we've got to do that. Unless we become what's called our own OID and we maintain our own standard, which I guess we could do if we wanted to do that. So there is a pathway if there's strong support for coming up with our own impression list and our own conditions list, then yes. We have a comment from Amber and from Peter. Hey, is there another mic? Oh, yeah. Oh, there we go.
All right.
Yeah, Peter.
Sorry, did not mean to trump Amber. No, but the ICD-10 codes are the problem. You put someone out in the field and you get 7,000 different entries for a stroke. The average provider out in the field, one, doesn't know all the presentations of a stroke because there are 21 different types. Most people don't realize them. They don't know the difference. And at 3 o'clock in the morning, they don't care. They want to do what's right, but at the same time, they have to look all the way through to find something generic. So we have to move away from the ICD-10 code, as our colleague over here stated, and make the list so it's realistic. minus the stroke buses that are there out in some of the states, they have no idea what type of stroke that person's having, because I'll just use Kelly because she's sitting here next to me and she's very tolerant of me. But if Kelly's experiencing a stroke, I can't tell which vessel in there is causing the problem. ICD-10 is intended to provide that specific diagnosis. We don't do that. We are routinely told in New York State that we as EMS providers are not diagnosticians. I bring in Kelly in because she's having a potential stroke. I'm not bringing her in because her left law artery, in this little vessel thing is having an embolism. We don't know the difference and we don't care. We know Kelly needs help. We know we're going to get her over to the CAT scanner and we know we're going to bring her to the right place. Why frustrate the providers out in the field? Use general weakness, other. Stupid little answers because they're the easy ones they can't find. The same as with the activities list. I was walking upstairs with carpet, walking upstairs on hardwood floor, walking up uneven stairs. Who cares? They walked going up the stairs, they felt they hit their head. We have to be realistic about what they're willing to do as well. We send them to a 200-hour class for basic EMTs. We're not sending them to medical school for 7 years.
Thank you, Peter. So Eric, and then maybe
just to say, as we start to discuss developing case definitions and things moving forward, not necessarily moving backwards, not in favor of those. These are the case example for why we should do this. Millions of dollars were let out from many different federal agencies and other agencies as well. And there was no standardization in the very beginning. Now people have built out many systems. People are going back now and develop standards like CSTE and others, which is great, but the genie's out of the bottle. People are not going to go back and redo their system and redo what they're doing just to meet a specific standard. I think we have to be realistic about that. I'm very, very interested in doing this and looking forward. I'm truly not interested in looking at this going backwards.
You totally came in the way of my good cop, bad cop routine with Peter over there. So. I can only imagine what a huge undertaking this would be. And again, it's hard to see how we would all agree on one case definition, but I think even speaking to all these points about ICD-10 codes and different way people document, think about how much we could learn from one another if we all combined all of our knowledge bases, right? If we learned why biospatial came up with their case definition versus Colorado versus CSTE, even if we don't end up with a final product that everybody can reach consensus on, we can inform our own approaches in coming up with case definitions. So while I think, boy, it would take so many hours and tons of work to share all the codes that we use in Colorado versus what they use in New York versus CSTE, I definitely think there could be a benefit if we're willing to take the time to have the conversation.
Anne has, and Peter in the back.
I was just going to say, I feel very passionate about developing standard definitions. One of the challenges that I see is related to the ICD-10 codes, in that oftentimes definitions aren't inclusive enough. Most recently in Oregon, we worked on a definition for suicide-related calls, in which we, reviewed 1,500 records and going through. And the reason for doing that in part was because, I looked at the ICD-10 codes, I pulled those records out, I presented it to our injury folks and they said, this is a gross underestimation. Like what, we need to look deeper into this. And so my question is, in terms of parsing the narrative and using some of those additional resources within the EPCR, is there a reason for that choice? And, can we go a little deeper with that? But then the other piece is just around all of the work that goes into reviewing records and so forth. And it's an immense job. What are some options for, funding that type of initiative or building sort of the capacity to do it?
Yeah, the case definitions in particular were built for researchers using the national database data. There's no narrative in there, right? And so that's a really important consideration, that it, depending on a usage and an audience and so on, it's going to be different. These were very specific to the national database and the national elements that are available.
So I was gonna add something, but I don't know if it's totally on par with this project. So we found because, okay, so what with Compass, remember Compass? So we thought, oh, great, we have these standard definitions, this is awesome. And then we would look at some of the stuff they were requiring, and we didn't happen to have it in our data set. I think that was a pretty common thing because states do their own data sets. We're like, oh, well, you have to do this or this or this. And it's like, we don't have those. So I know goes away from making it exactly the same, but what we ended up doing is, we couldn't find it in the ICD-10 codes because agencies could do what they want. A lot of times about weakness or whatever. We would look for it in any other possible element that would indicate that. Does that make sense? So sometimes we look or symptoms or whatever. And I realize that goes back again to making this all a little bit different, but it would be a nice resource if I could show our biostatistician I just sent you guys an email for suggesting like sepsis. I could say, hey, here's all the different places we might be able to find sepsis, because it's always going to be, I think it's always going to be less than what you really have. It's always going to be underreported. You're never going to, even if you look in every possible place. And we tried scan function, by the way, for narratives, and you can do it, but we tried it for falls and you get like chest rise and fall and all kinds of stuff. So we haven't solved that yet. Thank you.
I just wanted to make clear, I'm not against using ICD-10s. What I'm against is like coming up with these names for ICD-10 codes that are, Florida will have attacked by a whale or manatee, and California will have attacked by a shark, and they end up to be the same code, and that it then gets really confusing, especially if you start moving the data along. Just wanted to let that out there.
Yeah, it is critical that as we look at like suggested EMS friendly labels for codes, that we are not deviating from the actual meaning of that code. And that's a fine line to walk. But I think we can make it EMS friendly while still, walking that line. You can't just simply relabel a code and say, oh, we're going to use this code for this thing. Then stop it.
Oh, yeah. All right, well, thank you. Thank you for your comments. Thanks, Josh. Did you want to share a comment while I'm changing the slides, Jay?
So really, I think it's a good idea.
I'm just going to add, I think it's a good idea just to come up with, these are ranges of the ICD-10 codes that could be used across the nation. Knowing that we're going to have some, how should we say, ambiances with that. But at least the researcher that's looking for something can have some guidance to go through. And that's what I'm going to say. Yeah, the ranges that I think you provided and stuff like that, that's not such a bad idea. I think it's a great idea. And I think it can be very helpful.
So always got to put up on, while Clay is pondering the next topic here, I'll just brief comment on this one. And it's a good segue for this next topic. One of the things I mentioned yesterday was when I first started, I was at the 2019 NEMSIS meeting, and we talked about some of the state directors in the corner, and we were talking about some of the things I made a promise to them. Transparency was one of them. One of the things that was said to me loud and clear was that the comment was made. It was kind of a backy comment. What doesn't matter because Clay's going to do what Clay wants to do. That's what was said. And then I heard over the next couple of months as I started this project that, the TAC had too much power. TAC, they were going to do what they wanted to do. They didn't listen to this or that. And I don't think that was true, first of all. But I could see how some of that perception came about. There wasn't someone in our office. There wasn't a process in place for a lot of things to happen to where it didn't end with Clay Mann making a decision to move forward, not move forward, what the timeline was going to be, so on and so forth. And what I've learned is that no matter how many emails I send out or how many Google groups I use, I always miss somebody who points out that I missed them and they should have been involved in the decision-making process for whatever the topic is. And for that, I apologize because we try to include everybody on earth in any of the discussions that we have. We put out a monthly newsletter to make sure that you're aware of what projects we have going on, what the status of those projects are. We've been asked to put in compliance and compliance updates. So things like that, we are trying to do to be more transparent. So as we talk about developing measures and things, it's also an issue for me that I don't want us to be the ones that decide what mental and behavioral health is going to look like, period. I want your input as to what that's going to be. And there can be different ones across the United States. I'm not naive enough to think I'm going to get everyone to agree on everything. That would be fantastic. I probably wouldn't be standing in front of you if I had that power and capability. What I do want to do is make sure that we hear the different things that are out there. Ty talked to me in a break about looking at struck by incidents. And I'm jealous of what the USFA has, because for the fire side, they have done very well with near misses and struck bys and things like that. We have not done that well with the EMS side of the house. So the reasons for doing some of these things are not just because we can do them. It's quite honestly to take us out of the middle, because it shouldn't just stop with our decision. And that's a good segue for this revision cycle. We started to, and before anyone starts to throw any heavy objects, we have absolutely no intentions, none, of starting a revision process for 3, whatever comes after 3.5 today. However, we're going to talk about what that might look like for one very good reason. We have over 100 requests now for what's going to happen to the version after 3.5 already. None of those are from the Office of EMS or from the TAC. They all came from somewhere else. There are a lot of people looking at this data, a lot of people that want to use this data, a lot of people that want to tweak it for their own benefit, for their own projects. I recognize that. So I had this discussion with Clay and the TAC about how we're going to move this forward again, because it shouldn't be up to Clay Mann and Eric Cheney for what's in version 3, whatever's after 3.5. And I thought, well, surely there's a process in place. We've done this for years, had all these different versions. And I found out that it has been some processes in place, but there was held data elements, all these requests, or held all these requests to a certain point. And then we came together at a data managers meeting, and we have 2 hours to discuss this, and we have 270 elements to go through. And I said, well, that doesn't make sense. So what happens if somebody submitted something and it's a good idea, but it needs to be tweaked and we need to go back to them? How's that going to work? So we spent hours talking about this, what we're going to show you. None of it is set in stone. It's all for your input. But the intent is to establish a process where we start looking at some of these things now. Can we categorize them? Can we look at things that we just take off the table right up front because it's a ridiculous request? Our personnel are never going to do it. So we don't even have to keep it on the list. We have to consider it. Are there minor, moderate? Clay's going to talk about some categories. But I want you to understand the intent behind it. It's so that we're not, the buck doesn't stop with us. We want your input. I realize we're also going to need to take that input from you all and go to the state directors. And in some cases, the medical directors, and in some cases, the pediatric people. That's why we have this NEMSIS liaison person to help us navigate those waters. But we can't do that at the end of a change process, and we can't start that 8 years from now. That's something that should be ongoing as these things come in. That's the intent. I'll start from there and ask if there's any questions. So hang on. Let's talk about it.
All right, let's dig into this a little bit. So folks will remember that just the beginning of this year, the first few months, we published a revision guide. Most of this guide was kind of a layman's built guide that would help new data managers understand what's included in a revision, right? So what you need to think about schematron, you need to think about the state data set, you need to think about all these different attributes. We do in that document, I think, do a good job of talking about why we revise, right? And we talk in these, we don't need to go through all these. It's really that we want to, number one, improve the experience of our providers attempting to document their clinical care. Second is to more accurately collect that information, make it available for a variety of purposes. So I think we're all in the same place in regards to what needs to happen. The only guidance in the current document regarding a schedule for versioning is just a statement, right? And basic is just the first sentence. Every time we feel like we have enough information that we can't, we have enough revisions that we're beginning to not be able to reflect the changes that are needed in EMS care, that we go ahead and plan a revision. So that's the thing that we're trying to change. And I think for your states, for your clients, for the vendors, for federal partners, anybody who's interested in our standard, knowing what the schedule is will improve everybody's life. So let's dig into it. We've decided to just go through this using the same type of semantic versioning that we've always used for NEMSIS, right? So we have a major revision on 3, a minor revision. We have kind of a build date, and that's going to become, we're going to call that an informational change. So there'll be another level there, and then a build date. And then of course, we'll always have critical patches. We've released critical patches, I think 4 times with version 3. As we've rolled out a new version, we've you folks have helped us to discover something that we have not done well. So as Eric mentioned, we'll lay out a schema. I'd like you to see the entire schema for a versioning schedule, and then would welcome comments. The other comment I'll make that needs to be completely clear is, like Eric mentioned, we built this schedule mindful of all of the things that are important for versioning that would need to happen with every version, but focusing on how this would work at the national level. So this will fit the TAC. Now, what we want to do is modify that with all the other things that kind of need to happen, or if we can stay as close to this as possible. This is just the starting point, and let's polish this up to be something that will work for everyone. So let's dig in. So, and Josh, would love any comments. May want you up here actually, just in case we have questions about what's a minor versus a major. So first will be an informational build. So this would be a modification to the XML standard that just corrects typos, updates links, corrects a grammatical information, or as we talked about today or yesterday, maybe adding information about how to document race in the section where you can add comments. So this type of a version would be done no more than every 6 months, and it would not modify compliance testing in any way. Okay. We did a look, Jen, how many requests we have for changes? 140. Rough number is good for me, Jen. Okay, 170. 22% of those would fall into this category. So we could actually complete 22% of those suggested revisions. The next level up would be a minor release. Let's talk about a minor release. The major idea here is that a minor release would only include revisions that would allow the standard to be more permissive, not more restrictive. So here's some examples, right? So perhaps if we wanted to have a method whereby we could more easily incorporate new elements or things that are important to our industry, they could be introduced as a minor revision and included only as an optional element to begin. So if we feel like something's valuable, it would be added in a minor release as optional. Rules could be made more permissive. They could go from a hard error to a warning. We would add additional values to an existing element. We could downgrade a national element to a non-national, change the reoccurrence from one to one to many. All of these things are backwards compatible, meaning the data could be associated with a previous version. We're proposing that happens every 2 years on a schedule, and this would represent another 30% of that 170 that Jen mentioned. We would capture those with a minor release. Last or the last major category to talk about is the major release. That would include changes to the standard that are not backwards compatible. So if we're going to add a required or mandatory element, if we're going to change a warning to an error, if we're going to upgrade an element to become a national element, for example, that would be part of a major release. So for example, if we added a new element in a minor, it would be optional. States could use it, states could collect it, but on a national level, that wouldn't be available for as long as up to 6 years, right? For another major release. Every minor release includes all informational and minor releases prior to that, and every major release will include all of the changes that were made informational or minor up until that point. So if we put that, and then of course critical patches, those have always been ad hoc, but they have only been done if there was some change or functionality that was seriously compromising the daily function of the standard. So that, as mentioned, has happened, I think, 4 times. So, and that would happen at most quarterly. So if those are the classifications, thank you for your patience. Let me just show you how the cycle might look like, and then we can talk about that. So at any one time with this cycle, and I'll show it to you in a minute, the NEMSIS TAC would be maintaining 2 majors and 1 minor. Now so 3 versions, and as you can see, the major revisions, as you'll see, will stay open about as long as they have been, right? So about 8 years. All right, so here's what the revision cycle would potentially look like. So to be able to stand at this for just a minute. So if we were to move forward with this plan as it looks like now, this is what it would look like. We have a minor revision every 2 years. The minor revisions would be included in compliance testing, but there'd be no hard date, right? There's no like, you've got to be on this version by this date. What we would do at the NEMSIS TAC is that all compliance testing that happens during this period, and we'll talk about the process. So this is the cycle. We also have a revision process. All the compliance testing during this section would be on version 3.5.1. And if there was an optional element included, we would make modifications to the compliance process to ensure we're testing for those attributes. So no hard date. States could be on version 3.5 for as long as they want. They'd be missing out on this stuff. Their software would have been compliant for those periods with the minor revision as soon as they go through compliance testing. But the standard stays open for 8 years before we go to version 6. And then we would begin, or version 6 would, for example, in this scheme, a rollout in 2028, and it would begin this process again, right? So it would be open for 2 years. There'd be the chance for a revision beginning at 2 years through 2031. So it's a little bit complex, but I'll just show the next slide, right? So we would have to build these, right? We've got to meet together like we have in the past to be able to make these changes, approve these changes, and however process Eric works out is valuable for us. But there'd probably be a yearly process that's much like what we've done before, and there'd be modifications here clearly. But you remember we've always had like, okay, get any thought you have in for revision into us. We have had that open for 3 to 6 months in the past. We go through those revisions over the next 6 months on the DMC calls and on the implementation calls. We had work groups at this meeting, right, for version 3.5, where folks met together and we made some recommendations, and we spent 3 months working those recommendations through the DMC calls and the implementation calls. So that's about a year. So if we tack that on, then it looks like this, right? So we would begin, a year earlier for the 2 years to begin the process. So is this correct? Let me throw up the process or the cycle with the process and make sure
It's correct, right? So. Oh, oh, yeah, so that's not correct. So I apologize. I don't know why that flipped over. Yeah, this should. Um. Yeah, we're correct. That's the build. That's building it. It's open for 2 years, building open for 2 years, building open for 2 years before version 6.1 building. So that's what they would look like together. So comments? Josh?
Clay gave examples of what would be backwards compatible. I just wanted to give like a precise technical definition of backwards compatible. And that would be that if a document was generated and was valid in 350, if you revalidated it against 351, it would be valid. 352, it would still be valid. So that document created in 350 would be valid according to any 3.5 version. A document created in 351 would not be guaranteed to be valid according to 350. And what that kind of means is that state systems would have a responsibility to move to newer versions before local agency systems move. If they want to be able to allow an agency to move to 351, then the state needs to be on 351 first. So that's something to think about. And then also, we've been thinking about this in terms of both the XSD and the national schematron schemas. So that if a schematron warning was changed to an error, that would have to wait for 3.6 because that would be not backwards compatible.
This is Brenda. Okay, so some of this is a little confusing, but am I correct in that you said for 351, that may be inclusive of new elements and so forth, right?
That would be introduced
As optional, right? Okay, so, and I'll wait for the vendors to comment on this, but just from a state perspective, for those of us that don't, that have supplemental systems, for instance, operational data stores or data warehouses that we pull, separately and maintain at the state level. It's not our state repository. We just pull from that and have other things. That would mean that we would be reacting to all of those changes every 2 years. And if you, like our state with limited resources, I'm not sure we could keep our data warehouse or operational data store with this schedule for two years. Because right now we are in the process of trying to get that up to speed for our 3.5 version. So that would be a little concern of mine. And I don't know if the vendors could be ready for it all, but I know the state it would be a little difficult for us to keep up.
Yeah, and that's a really good comment, Brenda. I guess the thought to keep in mind, of course, is these are all backwards compatible. So the build is a little bit easier to deal with than one that breaks the standard. But yeah, it's worth. Yeah, David.
So these two charts right here, I don't understand the difference between them.
And I apologize, they're confusing together. So if you just want to look at the cycle, I can show you the cycle. The process just includes the year of development.
Okay, so would you ever, if you introduce something into say 361, would that never cross over into 352?
No.
Okay.
Because they would not be backwards compatible.
Okay, so then when you say that you could introduce a new element into 352, that would not be backwards compatible for some cases that we do. So if we sent, eVitals 100 to state of Utah, I'm guessing that the intake would choke. So
Right, right. So they would be listed as optional. So again, this is from the perspective of the national data. So thank you, David. It would be optional. We would not collect it at the national level. So yeah, as was pointed out by Brenda, and as you're pointing out, if the state chooses to collect that data, then they would need to make sure that.
And just
one last one, is schematron tied to these individual versions too? Like you mentioned, going from errors to warnings, but I thought schematron had a separate release.
It has a separate release, right, Josh? But it does tie to the actual elements and the relationships between the elements.
To some extent, but
Yes.
I think you could relax those constraints without changing the version of NEMSIS.
Yeah, that.
Yeah, Josh. So let's answer that question and then we need to stop for lunch. We're gonna pick this back up after lunch.
Yeah, they could be separate, but we've talked about them being together because ultimately affects the validity of a document. And at the national level, I mean, you've got a lot to track, right? You're tracking all these different states with schematron rules that they're putting out, and we're not talking about their schematron rules, only the national rules. But you've got a lot to track, so we want the national level stuff to be very predictable. So we've been thinking of it in terms of if it was either an XSD or a national schematron change, that would be part of this cycle.
So let's break for lunch. We come back, we'll address all the rest of the questions.
Thank you, everyone. We are going to extend our conversation about the revision cycle until 12:45. So that gives us another 20 minutes to get through that, and then we'll just shorten the rest of the presentations. So come on in and get seated. Let's get some good questions related to this topic. So we'll go through 12:45. Would you like to start with that?
While everyone is coming back in, Clay's gonna put the list of the changes that we have to date up on the screen. Obviously, we can only see certain sections of it at a time because the list is quite long. But you'll see that we've gone through and taken kind of a first pass at whether it's intermediate or I forget the categories already. Informational, so on and so forth. We've taken a first pass at that. That does not mean that that's what they would stay. It just means that that's what we assign to it, just on a rough first pass. The other thing that you don't see on this list is who submitted the request and sort of what the intent was. In some cases, it's pretty clear, like fix a typo in a data dictionary. But in others, it may be from a national organization, a national association or whatever. And as you start to look at those, and we've talked a little bit about having small groups take sections of these, maybe put together a couple states, data managers and a couple of vendors and someone from the PAC to help scribe and write on the process and basically look at maybe 50 of them. And we have 3 groups that look at 50 each, and then you all come back and present it yourselves. So that's one approach, but we want to make sure you understand where the requests come from. Because there may be some weight or validity given to it by the requester, for example. So more to come on that process. We're happy to hear any thoughts that anyone has on it. But the big idea would be that you all took a couple passes through them. And obviously some of those small groups, depending on what's included, you may need some pediatric folks, certainly some medical directors. Just depends on the topic.
Yeah. So this is just, we pulled these off the wiki. There's a public wiki where all these are available. So you're able to look at those. We'll post that again. That's a link. And maybe we could even post that on the virtual site as well. As to where you go to take a look at these. We have this ordering only because we went through these and attempted to list these as informational versus major versus minor, right? Just so that we could provide those percentages to you, right? So the information are clearly informational, right? Like, replace the term data with date. It's supposed to be date rather than data. So these are just correcting spelling errors or other hyperlinks that aren't working.
majors. There are not a lot of suggestions for new elements, right? So don't, feel like it's just looking for, incredibly complex changes here. There clearly are some deprecating elements. You can take a look at these, some schematron changes. Anyway, you can take a look through these. I think as Eric's kind of mentioning, the first idea is to make sure that everybody feels
Up there a second,
comfortable.
Clay. Go back up
Okay.
a little bit. Stop right there. So you can see we've incorporated, we talked yesterday about the US CDI. And some of these would be to make sure we're harmonized and coordinated with maybe US CDI. Maybe there are a harmonization with NFIRS, for example. So those are some other examples of things you may see.
Yep. And these, so anyway, we'll provide this out. And I think what you're indicating, Eric, is, as was mentioned, this is as three categories based on what's happening at kind of the national level, right? And we've had some early conversation about, well, there's some differences in what work is required at the state level. And that may very well be true for some state specific issues too, that are completely non-technical, right? This is a very politically hard one to get right or to educate about. So, yep. So any more questions on this?
And the key takeaway is this is not happening anytime soon. Please do not tell your state directors that we are doing this anytime soon. I'm gonna give one call. Now I'm gonna tell you next year, you make next elevator call. So when you call, why are you starting version? We haven't started reset. We're not reset.
Okay. Want to talk about the schedule again? Go back to the schedule. All right.
Doug Butler, sorry, moving right along.
Oh, that's. Because of the close down and startup. For a migration to a V3.6. So that gives a transition year, and then we're also hoping, because of this piece, that really you don't have to be on the latest version of for example 3.5 before you make the switch to these 3.6, right? We've in the past had like a 2-year window of migration, right, that we tried to get people to adhere to. Much extended period where you're just on a version and then you plan at that certain date to move across. So yeah, that would be a transition year. We can make that longer if that'd be valuable. Samantha, can someone get a mic to Samantha? Oh, I'm sorry.
Doug, we got Doug. He thought he got it now.
Yeah, I apologize. I remember my question. I kind of wrote down. So something like e-injury 3 and 4 with the triage criteria changes, the ACS, would that be a .1 release or would that be a minor release? Where would that fall in this plan?
Yeah. So that's a great example. That would be a minor release with two new elements that are made optional. There's a little bit of a complexity there, right? Because we would still have the mandatory elements in the XSD. So, wow, you chose the hardest one to even think about. And I don't think we've come to a consensus about what to do with that, right? There's new national elements, and we're just really not interested in going to another major release because of that. And we're gonna have to figure that out. We're still gonna have to figure that out.
So with the schedule, would that, if I'm reading it correctly, it looks to me like 3.5.0 would no longer be accepted at the national level, after December 31st, 2023. Is that a correct reading throughout here? So up until 2029, you would, NEMSIS TAC National would accept 3.5.0.1 and .2. Okay, thanks.
Yeah, that's correct.
There any dates about the development and the ramp up to those minor revisions?
Right. That's this other chart, right, where
Okay.
we've
So
incorporated.
this is the development.
Yep, the
Okay.
development cycle.
And that was a question at lunch, Clay. How much time would we give the vendors to develop or the states to prepare for? And my response was, we didn't set a very specific hard line. We put in the slide there 6 months, but that
The
was
slide here is a
development.
year. Yeah, the slide here is a year, but yeah. It's just-
So
Do you already know what's gonna go into 351?
Well, probably what's listed as minor on that list. Right, I would imagine, we could do an informational. And then, we could start working on 3.5.1 in 2023. And go through the items we have now. Out of that 174, choose the ones that are listed as minor. We'll make sure that everybody agrees that they are minor, that what we've described as being less permissive, that meets the requirements at the national, state, and at the agency level. But once that's approved, yeah, I think we have a good list.
When you guys, I guess, how soon will the vendors get that list?
Well, so again,
yeah,
I think
let's back up one step. This is our kind of going in recommendation. This doesn't mean this is going to start at 2023. This could go to 2024. So we're saying this is what this process looks like if we laid it out starting today with what we proposed here. But we may not be able to start in 2023. That's
But we could.
what we could. And
So-
if everyone agreed that we were just gonna do those minor edits in 2023 and they weren't gonna affect anything significant, by our definition of significant, that's why we're asking you about your definitions of those things, then maybe 2023 is a reality. And remember, I'm from the federal government, so when you're trying to figure out how to do things, just add, multiply times 3 for the time on a project and double it for the budget, and you're pretty close, right? So a timeline of 6 months, we're in September, October, November, and December to get into 2023. For the federal government, that's on fire, right? So we realize that's the same thing for state government as well. And plus, we're coming into, let's just be honest about how life works. We're coming into Thanksgiving, Christmas, the holiday season. We're also coming at the end of 2 years of COVID, where people are really now just starting to catch up on vacations, and family times and things like that. And we have to be aware of those types of things because they impact all of our work. And some of you are coming off of just horrendous times of trying to get data in, meet reports, meet changes and all those things. So our example going in for the room, not necessarily set in stone chart, but when we're going to actually do things. Remember in the beginning, I said, there is no set timeline for this.
I have one question of clarification. So, would a vendor have to go to compliance on each of the minor versions? Or is it if, when they come through their compliance cycle of every 2 years, they would be getting compliance on the latest version?
That latter statement is correct.
That's what-
There would be no set timeline, just when you come in for compliance in that 2-year phase, you test on that
We have
revision.
to onboard every version?
You mean on board with the
With
state?
NEMSIS?
No, because it's a minor revision. There wouldn't be an onboarding like there was with, V2 to V3.
Hi, Clay. We have some questions online from Judy Whitfield and Benny Shalev. They're questioning if 350 will work for 351, 352. Just some clarifications on if in fact 350 is, what is question is if it's gonna sunset in only 1 year. Just a little bit more guidance and direction on that.
Yeah, thank you. So we'll talk about more about what like backwards compatible or not backwards compatible, kind of what that really means. But what, in essence, what is being shown here is that version 3.5 will stay open until 2029. And any version would be open during that period. We would hope it would be hard for a state to stay on 3.5.0 because their software has passed compliance for 3.5.1. You should move forward to it. These are decisions that you made. And as soon as they're compliant, you could move. But there's not like a hard date for 0, for 01, 02.
Right, and just want to clarify the way Clay said it. So we would hope that the state moves forward with it. However, it's not because of the technical reasons and the software. It's because hopefully the content in it would be significant value that you would want to bring in the 351 with the changes that were made, or the 352. Because the latest version of monkeypox came out and we made that a custom element in this or something. The idea is not to change, but change because there's some reason to make this revision before a 6-year or 8-year or 9-year process. And that's what we're really trying to build in here. We're not trying to change just to make something up.
Clarifying question on the backwards compatibility. So it sounds like if I say we're in 2025 or so, and we have our 351 and our 350 out. If a state system still has a 350 database and parsing mechanism, it will not be able to take a 351 file, right? But if a state or system has a 351 parser in their system, it will be able to take the 350 file and a 351 file. Okay.
Yes.
So that functionally means that the state systems would have to go first before their customers pretty much every single time, right?
Yes.
So I'm reading this and words are hard for me, but all right. So currently right now, you're looking at this basically that some of these changes were recommended, and like you mentioned, they might be important changes that we want to make. So rather than rating, and obviously this is all just estimation on dates, right? So rather than waiting till 3.6, we're basically giving the opportunity to take some low hanging fruit that we can develop in our systems rather than doing a bulk 3.6 upload and update in 2026. I don't know why I get out of breath when I talk. So just as now we're supporting some states that are going to onboard with 3.5 and 3.4. So we already know that in our records, we're going to have to, support 2 data sets. All we're doing here is just saying, here's some low hanging fruits, some minor changes, some backwards compatibility that we could apply for a state that wants to go to 3.5.2, for other states that want to stay 3.5, just like we're supporting 3.4 and 3.5 right now. And one other thought I was going to try to summarize. I lost it. But basically, all I'm trying to say is this: it seems a nice layout here, a nice way for us to not do some kind of bulk update years down the road to get versions deployed.
Right, and changes made. Yeah,
and the other part of that is we're putting that schedule out for the next 9 years now, so that it's coming. So if you have to ramp up a team, or you have to, we have to look at resources for something, we know when we have to look for those specific things.
Question about how state certification is gonna work with the yearly certifications, like say random state, California, is moving to 3.5.1, right? But 352 is now we have to certified on. Will California accept the certification?
Yeah, I think this is the first time California is seeing this. And so I'm not sure that they're in a position to respond. You can certainly respond if you have thoughts. Yeah, they may,
So we'll give them some time to think about it. We're not singling out any other state in here either, so let's be fair. Let's be fair about that.
I think you've already answered this and I'm sorry. But can you explain the difference in the versioning? Like what would be in 351 versus 36? And I think you've already explained that, so I apologize for making you go backwards.
oh, right, yeah. Oh, no, it's a great question. It would be the major changes, right? So you're allowing for a major release to happen. So the 48 things that are currently in the list that are listed as major would be incorporated into 3.6. But not in any part of the V5 or any of the minor revisions. So a minor revision is changes that are backwards compatible. So what that allows for, right, is that and of course, I'm just making a statement from the national level, right, that we'll be able to accept 350, 351, 352 into the NEMSIS standard with no need to keep track of how many versions we're keeping open, or hopefully for you for reporting will be much easier, that type of thing, right? So the backwards compatibility of legacy data is preserved.
You want to see an actual example? Pull the spreadsheet back up.
Okay.
So a good example would be that, yeah, kind of the effort. So
I'm sorry. Mhm. Yep. Yep. And we'll review these things, right? So I appreciate the comments on the individual things. We'll go through all these, right? Those that we would consider informational would be clearly reviewed and discussed. And if they were thought, no, that's minor, then we'd move it out of informational. If there's something in minor that you say, no, that's major, well, then we'd move it into major and it would wait till these 3.6.
I just wanted to reiterate again from a state perspective, since we have supplemental systems that are fed by this, things like, moving an element to one to many, that's a lift for us to do because we've got conversions to do and that kind of stuff.
Yes.
Here again, maybe easy for the vendors to do, but it's not necessarily easy for the states to do. So.
Yeah, and it's a good thought. And the things that we put in that minor category, we've generalized those as all permissive, but you're right? Like a one to many would be a big minor change, right? And I don't know that there's any in here that ask for a change in occurrence. I mean, that would be a rarity, I imagine. I don't know. I can look through this and see if there is, but. Oh, is there one? There's even one showing? Okay. Oh, perfect. Yeah, make occurrence 0 to many. Yeah.
And Clay, I just wanted to add Monet, I think it was Monet, don't quote me on who it was, who has an explanation of what a minor change is, what a major change is, and what a significant change is. And it could have been Jen that did it too, but one of them has a presentation that was shown to us not too long ago that I think would be useful if you would share with this group.
Great. Yeah, there's a layman term document that actually includes a layman's term of those terms. Yep. And we can review that as well. We have a couple more questions.
So Clay, I remember there was a conversation and maybe I'm missing it with the graphs, but wasn't it NEMSIS was always going to support 2 versions simultaneously? And if you look at that, it doesn't look like that.
Yeah, not simultaneously.
Well, we did 3.4 to 3.5 and we overlapped. We did
That's two.
3.3. Well, yeah, two versions simultaneously, but this looks like it's gonna be three
Oh.
stops, then, so there's no overlap between 3.50 and 3.51, no overlap between 3.51 and 3.52. There's no overlap in order to allow us. Anyway, that's just how it looks.
Well, you're right. You're right. So before we had a
Could you
major.
say that again? I'm what? No, I'm just.
It didn't sound very good, did it?
Could you guys cut that out of the transcript? Yeah, back up the tape. Yeah, with this process where we're not like just this giant move from one to the other, then we're not we are still maintaining two versions. So in 2028, there are two versions going simultaneously, but well, here. Minor revisions, right? And we can go through that process again, but again, for the state of California, for your servers to be able to handle minor revisions, I don't know why you'd have an overlap, right? Because they're always backwards compatible. So you'd have that kind of legacy ability to kind of always connect to the other data sets. You don't have to start a new data set, there will be changes and yes. Yeah, so this is all technical, right? This isn't education. This isn't, informational materials you have to develop. All those things we would be helping with, but yeah, we would be doing those things, just not like every 9 years and having hundreds of changes at a time. Yes. Come up, Mike.
So your question about the major overlap of major changes in that gap here where there's just the green, we'll be collecting 3.50, 3.51, 3.52 at the same time. So we'll actually have an overlap of all three of those during that green section.
Right. When we get out.
Yep. Yep.
Yep. The data set won't care as much about it, but Florida will need if there's optional elements in version 3.5.1 that they want to use in their state, well then, yeah, there'll be an education piece to it. There won't be any new required elements for Florida. There won't be any new mandated elements for Florida because those are a major release. Those would wait until purple. So yeah, states would have to take a look at the list of minor and say, okay, what's our burden here? Okay, a couple last comments. I know we've got some, yeah.
Yeah, so Benny was asking online, so 3.6 might go hand in hand with the next NFIRS version.
Ooh. We have a no comment from the audience here, but it could.
I'm gonna switch gears a little bit. And I can't remember if this was talked in the slide that had all the months in it.
Okay.
But do you guys have a thought on what that time gap is in between locking down what's in a version and when it's released? So how many months are you thinking you give vendors to build it?
Yeah, so that's okay. So Keith, you're going to have to help me a little bit with this. So what we see is the elegance of this is that on a broad high level scale, because the data, the legacy data for minor revisions are backwards compatible. So the data would remain compatible for the entire green. I don't know that there's lockdown or move over time.
Maybe I can rephrase my question.
Yeah, please.
So let's assume we want to release 3.51 on January 1st, 2024. Okay.
Okay.
We'll just assume that.
Okay.
do we know how many months prior to that you're gonna lock down and say, this is what's in it, these are the changes? Like, how much time are you giving us to build that?
Oh, right. So.
And states to prepare for it. It's
Yeah,
not just
yeah,
us.
and states were to prepare for it. Yeah, so this just has an additional year. This just puts a year on the front of each of those minor revisions.
So if 351 is going out at the beginning of 2024, all those changes would have to be fully decided in the next 5 months. That's what, in that scenario, you're saying, right? They'd have to be all set in stone on Jan 1, 2023.
Or, right, and we could
Okay.
extend this out, but the way it's written right here is that all changes would just, all the discussions, all of the finalizations and changes would occur in 1 year. But that can move out to 18 months, it can move out to 2 years, whatever you want, right? We could begin on version 3.5.1 much earlier now.
Yeah, no, we need a date to
Yes,
say no more changes are happening, right?
yes,
Okay.
yes, and that will happen.
Let me take a shot. So if we're gonna do this in 2024. And it's gonna go into, we're gonna have 3.5.1 available on January 1st, 2024. Dan's point is, Image Trend wants 1 year from January 1, 2023 to 2024 to build it, and the state have that time to get ready for it to ingest it, correct? That's what you're asking, or a timeline.
A
6
timeline, yeah.
Whatever that timeline is, it goes in front of it, which means if we were starting this today, which is why I said what I said earlier, this is for discussion purposes, we would have to have what was going to happen when January 1, 2024, thought about, discussed, done in the next, between now and December 31st. That's essentially what you're saying, correct?
Right, some time frame. Yeah, we could decide on how much time that is, and maybe more than a year, right? For states
Right.
to prepare.
And we've had this discussion, but we've not had this discussion with a group. What we assume January 1st by this graph, is January 1st the best time to implement that change? People tend to like to do it because they have a full calendar year's worth of data. That's always the answer we get when we bring it up. But then we also hear about conflicting things that happen the first of the year. So again, just another thought process. And this is day one of this discussion, ladies and gentlemen. So we're not going to have all the answers today. Other questions or concerns? When you have that aha moment at 3 o'clock at night,
Yeah.
you wake up, feel like you got to email someone, send Clay and I an email and say, hey, guys, you missed the mark on this, or here's some things you need to think about. And we'll add that to the list for some of our discussions on our call.
Great, fantastic. Thank you very much. That was very, very helpful. And we'll continue to build on this with each of the V3 implementation calls and probably with the DMC to work out some of the issues associated with state requests and needs.
All right, I'm going to pull up the next slideshow. While I do, I want you guys to stand up and stretch for a moment because I see that after lunch lull happening in the room. Don't go too far, but stand up and stretch. All right, if you can move back towards your seats, wrap up your conversations. We're going to keep going. We have we have just about 1 hour. Just about 1 hour left before we're done for the day, a little over an hour. We have 2 more topics we're going to try to fit in. So if you need to get up and go to the bathroom, feel free to do that. But otherwise, we're going to try to fit in 2 more sessions as well as some Q&A at the end and get everyone out of here by 2 p.m. So thanks for your after lunch attention. We are going to jump in. I know we've been talking about versioning a lot in the last few hours here before and after lunch, and we're going to focus in now on version 3.5. And I know for a lot of you, this is your world right now. It's what you're working on. It's on your to-do list and your emails, and it's what you're asking questions about and leading training for and coming up with resources for. And so it's very much on your radar. And so we're going to focus in for the next 20 or 30 minutes or so on version 3.5. And during that time, I'm going to do a couple things. Some of our goals are to point out to you on our website, if you're not familiar with this, where some resources we have created are located.
And really just in the last week or two, I've heard from some of you and gotten some documents that we have not posted yet, but we will be adding to these resources. So I want to show you where to continue to look. And then after that, there's 3 states in the room that are a little further ahead in the 3.5 process than others. And I've asked some of you to share just a little bit of your journey of what maybe what you've learned along the way, what you might recommend to a state. Or if you do have resources you've created, you'd be willing to share either individually or on our website, if you could mention that as well. So we'll hear from some states, and then as we have time at the end, Ben Fisher can also give some kind of field level examples of changes and what version 3.5 may look like in the field. So I'm going to switch to our website here. And essentially there's two sections on our website where you can find a lot of this. So you all are familiar with our website. If you go to NEMSIS.org, and if you are on your computer, you can look at this perfect. Thank you. You can look at it as I show you, or you can just look up here as well. But under this tab, using EMS data, there's 2 sections that are the main places you're going to look to find the version 3.5 information. One is this NEMSIS 101. We look at these 2 sections. We're going to look at NEMSIS 101 and the version 3.5 revision. And so let's look in NEMSIS 101 first. And this whole page is really a great resource for data managers especially, but software developers as well. If it's not something you've looked at, I encourage you to check it out. And as you scroll down, there's some blue tabs here that you can jump to a part on the page, or you can just scroll down and see all of it. But we're going to look in state-specific tools, as well as this understanding NEMSIS version 3.5. Those 2 sections have some great resources. And so state-specific tools, one thing here that I know Cameron mentioned earlier today is the body camera document that they made. That's available here if you're looking for that. And then this one, the version 3 change checklist for states and territories. That is really helpful and will give you some detailed information and important things to think about and steps to do in the process. This document I was going to mention as well, if as you've met people here this weekend and you think, oh, I remember so-and-so, Anne from Arizona mentioned that she did this or used this or had this problem in her state, I want to reach out to her and ask her a question. This link has an Excel sheet with contact information of all the state data managers and their emails. And it also has information on vendors and their contact information as well. So I'd encourage you to check that, make sure it's up to date and accurate for your state. Let me know about any changes or updates, but that's a good resource I wanted to mention too. And let's see, if you scroll down a little further, or if you click on the different blue box on the top of the page, is this understanding NEMSIS 3.5. The role of the UUID, I know Clay did a whole session on this earlier, but this is a document that explains a lot of that change and what it will include and what it won't include. And so for people who are hearing about that or maybe nervous about it or need more information, that's a good resource to share with them. Incident patient disposition, some of the changes to e-disposition 12 that is going to be broken up into 4 elements in the new data standard. There's some information on that there. And then harmonizing version 3.5 with CARES and with other databases, and information on that can be found there. I think that's all I wanted to show you on those 2 sections. And then the other section is back to the top here under using EMS data. If you go to the version 3.5 revision, hopefully this is a page you've seen before. If not, I'd encourage you to check it out. But there's several links here you can see. And this first one is a list of resources. So if you click on that, it will take you to several documents. Some are Excel sheets outlining specific changes and elements, what's been dropped, what's been added, what's required, what's optional, all those things. let's see, there's a version 3.4 to 3.5 schematron rule comparison that may be helpful to you or to software vendors building this as well. I think this was last year, Chip in New Hampshire shared with us a document that he had created for his state that may be helpful for you to use or adopt for your state. There's a sample of a data dictionary for version 3.5, kind of a gap analysis again of the changes from 3.4 to 3.5. And then these last documents are specific examples of a hypothetical call essentially for a field level provider of what it will look like, what those changes will look like in the field for version 3.5. So those are really the major two places. So again, using EMS data under NEMSIS 101 and under version 3.5 are kind of the two places to look currently for resources. And as we create more, as we hear from you of things that may be helpful, or as you share resources that you want to share or willing to share, we're happy to post those here for other states to use as well. I would like to take a few minutes now and talk to and hear from a few of you who are a little further along in the version 3.5 process. If you could share with some of your peers kind of what this has looked like in your state, maybe steps you've taken, timelines, any advice you may have for them. Anne, are you okay to go first? Okay.
Hi, Amber in Colorado. I think the first piece I want to mention is I am so pleased that that camera is now facing me. But in Colorado, we're fortunate enough to have an entire team that helps to work on this project. So first and foremost, those of you who don't have a team, I'm so sorry. Please rely on all of us to get resources. It really has been a team effort in Colorado. Every Thursday for the last, I don't know, 6 months, we meet for 2.5 hours and do 3-5 work. So tons and tons of work, lots of conversations. It's been long, stepwise. I would say for us, a lot of conversations have been how we can focus on the big picture and really just highlight high priority items. What needs to get done? When does that need to get done? All the other stuff can happen, you know, fill in the cracks. A lot of people have asked about what our process looked like. I'll give a brief overview. Okay, maybe you come to the front. So I get to be on camera more. Yeah. Yay.
She just right there. Or you need this for online, but you'll have to use it.
Oh, great. Lovely. Okay, so for us, the first step in Colorado, all of our requirements for EMS data fall in statute like many others. And so the first thing we had to do was update our rule set. It's like a year plus process. So when we talk about these minor revisions and trying to get there, I'm not going to update my rule set every single time, only big changes. So anyway, involves lots of stakeholders, lots of lawyers, but it was a good opportunity to get input from our stakeholders early on about different changes, what their priorities were, what kind of questions they had. So as painful as it was really helpful too. Next big thing, kind of simultaneously, really study that 3.5 change log that's on the NEMSIS website. That's been a really helpful tool. Thank you all. And then immediately afterwards, it was messaging. We put on a town hall to let everybody know here are the changes that are coming. Sent out blast emails. That's a common theme here, so you notice that. Then we started talking about run form, validation rules, creating a schematron, painful, but got through all of them. Defined list was kind of fell after that. Again, we really focused on what was necessary to have a product that was ready. We can go back in and update, fix things later. So I highly recommend that. Now we're in the process of rewriting all of our 3.4 reports into 3.5 world. So we are technically live, but we're not getting any data from agencies yet. So as we're rewriting all of our reports that we send out, we're also having conversations with vendors about testing. We've identified agencies who have started testing in the direct entry world, and are thankful for all the vendors that have volunteered to help testing as soon as they get on board. In Colorado, we have a dozen different agencies, so I feel the pain of many of the other states. Let's see, what did we learn along the way? In my opinion, I think it kind of falls on the responsibility of the states to really drive this change. We can provide the tools and the motivation for our agencies to have those conversations with their vendors about moving to the next version. So it's been helpful for us. Though in Colorado, we don't come across with a heavy hand. We do a lot of technical assistance. We allow a lot of leeway. We try to open the door for conversations, but really have pushed folks to talk to their vendors, understand what changes need to happen, when they're going to happen, that sort of thing. We learned compliance testing doesn't cover every aspect of the product. That's been a critical piece of information that we had no idea about before. So that was interesting. Some gripes about the new state data set approach, but I'll leave that for another day. And let's see, main advice for those starting out. It is so easy to get trapped in the weeds. I can't think of how many times Bill and I got stuck in a conversation about a single data element, or where it should be on the run form, or when it should be required. When you get into those tough conversations, I would say table them and circle back so you can just keep moving forward. That was a big thing. Just keep making progress. We need to get closer and closer to that launch date. There will always be things that you get trapped in the weeds about. It doesn't need to be perfect the first time around, especially for Colorado. As an early adopter, we knew updates were going to come, fixes were going to come. We're probably going to screw something up and won't know until someone tells us. So give yourself grace and provide opportunity for people to share that kind of feedback too. And then lastly, develop strong relationships with your vendors. Give grace to them too. They have a ton of work on their end. This is new for them too. They're figuring it out just like we're figuring it out. Have lots of conversations. And developing a tool for states may look different than for agencies, and even between different agencies. Trying to balance the needs of what this agency wants versus what this state wants. I can only imagine what they all have to do. So, and then resources to share, like I said, that 3.5 change log, super helpful. Chip's table that he created of, I don't even know what it's called, all the necessary changes, that was super helpful. And feel free to steal anything from us, our run form, our validation rules, whatever's in the library, take it, ask questions, make it better, tell me how to make it better. We're totally open for feedback. Bill, did you want to add anything you're missing? Okay.
Thank you, Amber. And Amber, when you say it's available in your library, do you mean your state page on the NEMSIS website? Image shared library. Okay, perfect. All right, Peter, if you wouldn't mind coming up and sharing a little bit of Oregon's journey with us.
All right, we'll see how this works. I'm Peter Geiser from Oregon, and many of the things that Amber said ring true to me as well. We have a very small but mighty team, but I give credit where credit is due. A huge part of us being where we are with 3.5 is working with Josh Legler, and his support in this has been critical. like many of you, I've been reading stuff since last year before the boot camp. But we started a lot of this work in earnest the beginning of this year in January, planning, putting together a communications plan, a timeline, looking at all the things that were going to need to be tested, and putting together a project management tool. And a huge part of that process was really just about managing expectations on the part of all of our agencies throughout the state, our state committees. And so we put out there very early, here's what the timeline is, here's what our goals are. And our plan was that between July, and you may know that was several months ago, and December, we were going to begin onboarding agencies who use our state system, our state image trend system. Obviously, that timeline has been delayed somewhat, but we are still hopeful. And then between October and March of next year, we would be working with third-party agencies, and over the summer, meeting with the third-party vendors to make sure that we had a solid plan in place. And our primary goal was by July of 2023 to have 90% of agencies transitioned. And I'm a firm believer in setting really ambitious goals, and then hopefully we I don't know, we'll get there when we need to get there. But currently, Josh completed our state resources and posted them to the NEMSIS website recently, and testing plans. We're working with vendors and scheduling meetings with vendors to schedule the implementation and communicating with our agencies. We have an active survey out to our agencies to see when they plan on transitioning, so that we can put together a timeline and a schedule for the agency level transitions. Let's see. And then the other piece right now, we're just waiting on this next release from Image Trend to be able to test the web services before we can begin moving on some of the agency transition pieces. In terms of things for folks who are in the thick of this, I think the things that have been really critical to us are planning. We're trying to think through who the right people are that need to be in the room, and communicating a lot with everybody throughout our state, and being compassionate with yourself, because this is of course really complex, and there are a million monkey wrenches that can get thrown into the works. We have one integration that I have no idea when we'll have that completely sorted out. And of course, feel free to reach out to me with any resources that we have, happy to share. So.
Cassie, do you want to come up?
Yep. Hi. So I'm pretty sure everybody in this room and most of our audience online already knows who I am, but I'm Cassie. I'm from Georgia. So much like Ann and Peter, I'm not as far along as Ann and her team, but I mean, Amber, sorry, I was doing what you did. Amber, sorry, Amber. But yeah. Well, it's because we've heard Ann from all day. Anyways, we got a small team in Georgia that has been working on this as well. We did a backwards approach to this. We took a lot of lessons learned from the last big update. And we said, this is not what we want to do again. So with that being said, we did a strategic plan. Went through all of our validation rules. We take a lot of feedback from our agencies as well as vendors. I 100% agree with Amber's statement of build relationships, because those are important, because you're not in this alone. You are in this together. It takes all of us to make this work. So we started looking at our validation rules and what issues we were having, what we needed to modify, what would work well for us in 3.5. We put that in a spreadsheet. We color coded it so we know where to go when we start building our validation rules. We have a data committee. And so on our data committee, we have vendor representation in our state. We have air service, ground, MFR. We have government, hospital base, and then our office. So we have presented, the first step is like Amber state, we're built through statutes. So we had to update our policies and our rules and our regulations for some of the changes that are coming out that Georgia's fixing and get ready to do at the beginning of next year. Those are still in the final works. They have in the final drafts. So the next thing that will be is to communicate the changes with our agencies. So the next thing that I have done is I've created educational documents. And thanks to the NEMSIS Tech and Chip Cooper and everyone else who's already given us great resources already. But I went through and I put what was the most important for my medics and my agencies on what's going to be the most difficult. And the one thing that I wanted to show is the dispositions. So here I've created a flow chart, because to me, my medics are easier to understand what a flow chart looks like. So here I give them an example of when they made patient care and what they go as documenting through each, from refusals, from cancels, from transports to turn over to another unit. And I found that this is most important because the education piece is what's going to come first, because that's going to help us in the process when we do transition over. And I have this available. If you would like it, I'm more than happy to share this with you. I haven't shared it with my state yet, so you're the first ones to see it. Yay. Our next step is creating more education documents, getting it out there and getting our agencies moved over. However, in Georgia, we're a little bit different. So everyone has to move at the same time, but we're doing it in stages. So our direct entry users will go first, and then our third party vendor users will go in the second and third stage. But once we turn off 3.4, there is no more 3.4 in Georgia. So thank you all.
All right, thank you, Amber, Peter, Cassie. I appreciate you guys sharing. And I know probably the best way you guys can learn is from each other. So keep that in mind as you're working through this. Feel free to reach out to others, reach out to us if there's something you feel is missing that you would appreciate us to create or to share something you've created. We're happy to do that. And we very much understand that it's a big part of our role in this transition. I think we're out of time for this session, but I'm going to call up Ben and is it Jen, I think, are the next presenters.
We actually have just a quick minute if there are questions about 3.5. So we have a minute or two before we need to go to the next session. So did anybody want to talk or have questions about 3.5 transition, or want to ask questions of Amber, Peter, or Cassie? Where? Oh, yep.
In the states who have already developed their sort of training for the vendors, share it with the vendors and the other states as soon as they get it completed.
Can they, sorry, I missed the beginning of that.
The training, the training documentation that they've assembled for their respective users in their state.
Which states have created?
Yeah, if you can share them with us, share them with your peers.
Yeah.
As soon as you get them done and ready, it'd be awesome.
Yep, I bet they're willing to do that. Thanks. Any other questions? Okay, thanks, guys. You don't have a presentation.
It's that one. Nope. That's okay. So the next 15 minutes or so we occasionally solicit feedback from both states and vendors about reports and dashboards that would be useful for you all. So we've heard some kind of suggested topics about things that would be helpful, but this is a time for you all to, now that we've spent the last 2 days or so talking about Tableau dashboards, reports, and some of the other offerings we make available, what would be helpful for you all in terms of dashboards and reports, if you could wave a magic wand and have us produce anything?
Wendy.
I would like to suggest that we have the ability to change the dates. Because right now you can only do like the past week or so. And so I would like to see information from last year compared to this year, that type of thing.
Like to have names instead of agency numbers as well? Is that ever gonna be a possibility?
We,
Because those numbers are different.
again, one answer to that is the national DEM file doesn't include the name of the agency. So we don't actually get that at the national level, but we could pull that from state data sets. So maybe that's what we ought to do. In some way, incorporate that into the dashboard. Great, thank you. Yep.
And that's, yeah, we'll look into it. I do know there are some limitations in terms of how, just because the data set gets so large, windowing the date range to an extremely large period, but this is there are no bad ideas. We want to hear them. So yes. What else? Nothing. They're all A+, amazing.
No improvements necessary.
So if you're asking about reporting, one thing that a lot of people at like NEMSIS and some of the quality improvement groups I'm in want to see is some kind of a way to benchmark their performance measures against national numbers. So maybe building some kind of a dashboard that you could see, you know, the NEMSIS measures and in national numbers. And then I could go in and say, okay, this is my agency performance. This is what national has, and have, you know, some kind of comparison.
Yeah, great.
Yeah, so that's a great question. We've actually built that. And the states can look at agencies and actually compare an agency to their state average and to the national average. We really need to work out a mechanism whereby agencies can go in and do that. So we'll work on that.
Hang on one sec.
Sorry, would there be an option to open that dashboard up to vendors as well, or is there anything that would hinder? Like, is there something that we wouldn't be able to see that states do?
Yeah, that's a good question. We can look into that. We can look into it. There may be a harder sell for vendors to see agency level data for some strange reason, but we can look into that.
Or, yeah, were you asking for like your agency information or?
Oh,
So full state comparison to the national level aggregate, okay.
If we're doing something to that effect, are we looking at doing some comparison between the geography and the socioeconomic areas that they serve? So that my little town out in Paducah, nowhere, Schenectady County is not being compared to the 36th precinct in New York City?
Yes, I believe if we did do reports that included geographic locations that were accessible, we'd have small cell suppression and things like that, right?
I mean,
Right, and we also have a measure of urbanicity based on USDA urbanicity codes, and we're also talking about including some of the social determinants of health that the CDC has been maintaining, so. Yeah, there's work in that direction.
any other questions or ideas? And if you think you might need it, somebody else might need it too. And as always, feel free to reach out if you have ideas. I think it's called the 3 o'clock in the morning thought. Please email it. Let us know. We are always happy to hear from you guys. I know you've heard that a lot in the last couple of days, but it really is true. I don't think so.
right.
I think we're ready for the Q&A.
All right, yeah.
All right, this is just the final Q&A for us to make sure that we've answered or addressed any of your questions. If there are things that are lingering in your mind from topics that we've covered today or yesterday, looks like we may have some online.
No problem. Thanks. So this is, still has to do with the, previous topic. It's the this is, Brian Jacobson. Will there be a separation between U34 and U35 or will they be combined?
They will be combined if possible. If there are attributes that need to be changed, they'll be added to the existing dashboards at the national level. All right, any other questions, something lingering in your mind regarding versioning or UUID or common definitions or any of the other topics we've covered? Really? Okay, great. So have we done a good job of addressing the topics? Clearly, we have a lot of work to do. I don't know how many pages of notes we've taken, but they're copious. So we will spend the next few weeks combing through those, getting down the major bullet points that we need to bring to you topically on the V3 implementation calls, and then also on the DMC calls as well. So yeah, if there, Eric, do you want to come up and close us out?
Yeah, absolutely. So first and foremost, thanks for all the comments. Thanks for all the information, sidebar conversations. It is incredible to work with you all. There is such a wealth of information and wealth of knowledge across so many different facets of healthcare and IT industry and things that I don't even begin to try to acknowledge that I know. I said when I started yesterday or the day before, I'm humbled to work with this group, and I truly am. So if we start to go off the rails, if we start to head in the wrong direction, when we had our vendor meetings, I said to you, if we're doing something that's putting your company in jeopardy with something that we're doing for the states, if we're doing something that's causing you undue stress and headaches, please call and let us know. All of you have, I know my email address is Clay email address. I get calls from you from time to time. Nothing goes unanswered. I can assure you of that. Be safe going home. Take care of yourselves. And we look forward to seeing you again next year. Thank you.